Liu Das, Usha Das.
Learned Counsel Ms. Liu Das has prayed for withdrawal of the application.
My
Uh, the other side is not present today.
Lord, because it's my application.
Learned Counsel Ms. your name? Kebra is present for respondent number 5. Petition is dismissed on withdrawal.
My lord, withdraw. Obligement.
May I please, Your Lordship?
Yes, yes.
Your Lordship, I beg to listing of an MSc IA, Your Lordship. It's a release application. Let it be listed on next Wednesday.
Fine, you next Wednesday.
Release application for orders.
But not for orders. For next week, I cannot fix next week for orders. Only for motion matters.
Otherwise, it is listed for the, it will be listed for the first time. It has never been listed. This IA has been not been listed.
Okay.
Oblige. Oblige, Your
I'd like to mention listing of an FAO, my lord. My injunction application has been dismissed, my lord. It will come up for motion, my lord. Grateful.
May I please, may I please, my lord, I pray for listing of one CRP IO, my lord. My lord, this matter relates to maintenance, my lord. And the husband has not paid the, my lord, arrear as well as the current maintenance, my lord. So the prayer was made before the trial court for attachment of his salary that was rejected. Against that, the CRP is filed, my lord. So I pray next week, any date, my lord. Oblige.
May it please your lordship. I beg to mention item number 28 of the daily list, your lordship. Lordship, my learned senior is not well today, so could not be present before this honorable court. Your lordship will have to
Learned Counsel Mr.
J.K. Roy on behalf of R. Sharma.
JK
J.K. Roy on behalf of R. Sharma.
Roy on behalf of Learned Counsel Mr. R. Sharma has prayed for adjournment. List the matter up to Puja vacation.
May I please, Your Lordship?
Hmm.
Your Lordship, I beg to mention item number 27, Lordship.
Hmm.
Yeah, one of the close relative of Mr. Conducting Counsel, Mr. NLM has died, expired, so we pray for some time. Lordship.
Conducting Counsel.
One of the close relative of Conducting Counsel, Mr. NLM has expired.
Okay. Learned Counsel Mr.
S.A. Bakhtiar,
S.A. Bakhtiar on behalf of Learned Counsel.
NLM for respondents.
N.
Alam.
Along.
For the
Representing
respondents.
respondents has prayed for adjournment. Have you taken
We have taken time consent for the other side.
consent has been taken from the other side? List the matter after Puja vacation.
Any date may be fixed, Lordship.
List
After
the
visa
matter-
fixation.
22nd of.
Much surprised.
May please, Lordship.
Mhm.
I beg to mention for listing I am, my lord. I am for the claimant respondent in the MSCT appeal, my lord. Matter was last returned 23, 21, 3, 25, my lord.
Hmm.
Claimant is suffering, my lord, because payment has not been made, my lord. There is delay in filing the obliged, my lord.
May it please, your lordship. I beg to mention item number 40, lordship.
Oh.
The matter may be adjourned for the day and may be listed
1414.
40. The matter may be adjourned for the day and listed after the vacation, lordship.
Have you taken consent from the other side?
Yes, lordship.
Learned Counsel Mr.
May I please, Your Lordship? Your Lordship, in item number 40, I am appealing for the appellant.
Appellant. Learned Counsel
Yes.
Mr. D. Mondal is present for the appellant. Learned Counsel Mr. Your name?
M. Ahmed,
M. Ahmed is present for
S. Roy,
Yes.
on behalf of
S
S. Roy.
is present on behalf of S. Roy, former respondent number 2, and has prayed for adjournment. On behalf of Learned Counsel, Mr. S. Roy, representing respondent number 2. Full stop. The respondent has prayed for adjournment. List the matter after Puja vacation.
Obliged.
Lordship, I beg to mention an of CRP IO.
Hmm.
It has been filed today. The petitioner actually, the PW5, it is in the trial court. The next date is on 25th 9. So, my lord, please, on 22
For what?
for orders.
Orders.
Motion.
What
it
is
should be
the,
motion.
what is the emergency?
Yes, the PW5 is not cross-examined. The learned trial court closed the PW evidence and on 22.
May I please, Your Lordship? Your Lordship, I beg to mention item number 15,
Hmm.
admission column, Your Lordship. I am the appellant.
Not next week. Not next week.
Yeah, Your Lordship, any date after vacation.
Learned Counsel, Mr. D. Mondal, no?
Yes, Your Lordship.
With the consent of the
Other side, yes, sir.
Prayed for adjournment, list the matter after on 24th October.
Highly obliged.
May I please, your lordship? Lordship, I beg to mention IA 1374, order of disposal. Mr. IA has the matter has been compromised outside the court. Your lordship may kindly fix the matter.
Compromise?
Yeah, 22/9,
When?
22 Monday.
Monday.
Yeah.
Okay.
Please, Your Lordship, I beg to mention one IA civil. It matter pertains to RFA and RFA has already been admitted. Your Lordship, in the executing court, the execution has already been commenced. So the next date is on 25. So Your Lordship may kindly allow us to allow us a date before 25. Highly request.
Order number 1 for withdrawal.
May please. I have instruction to withdraw the case, my lord.
Okay. Learned Counsel, Mr. P.
Yeah.
Azhar, has prayed withdrawal of the, prayed for withdrawal of this appeal. Appeal is hereby dismissed on withdrawal.
My lord, my lord, we have deposited 50% of the awarded amount before the registry. Remaining 50% will deposit within 4 weeks.
As the judgment and order survives, as the judgment and order award, as the judgment and order in MSC case number 1492 by 2010 dated 3/6/2017 survives, the appellant has agreed to deposit the remaining amount of rupees.
My lord, we have total award was, my lord, 5,36,000, my lord. We have deposited 2,68,000. My lord, remaining part of the awarded amount, that means.
Remaining part of the award has already, how much you have deposited?
My lord,
How much you have deposited?
2,68,000.
2,68,000 out of 5 lakhs,
36,000.
36,000 has already been deposited before the tribunal.
My lord, 50% we have deposited before the registry, my lord.
Oh, before the registry of this photo.
Yes. And then they are at liberty to withdraw this. That observation, otherwise they will have to file
The
claimants.
the claimants have a liberty to withdraw or the awarded compensation from the registry of this court after proper verification by the registry of this court.
My lord, that statutory deposit that may be returned to the applicant.
Statutory deposit is to be returned to the insurer.
My lord, I'm obliged.
Item 2, in terms of the above observation, this appeal stands disposed of, send back the original records to the tribunal.
My lord.
May it please your
Mm.
lord. My lord, this is an appeal, your lordship will find, my lord. I am sorry, your lord. This revision of my lord petition is against an order passed by the learned lower appellate court, your lordship. Your lordship will find that order annexure 12 at page 28, your lord. Now, the appeal was filed, your lordship, against an order, my lord, 27, my lord,
Evidence already
2001.
before us. You are a caveator?
Your Lordship, yes, I am on behalf of the caveator. I am appearing on behalf of Mr. T. Mozumdar. And Your Lordship, we have received the service copy 2 days before only. So some reasonable time may be allowed to file affidavit in opposition.
So notice may go and they will file their, my lord, affidavit. What happened in this case, my lord, I am telling that the learned trial court, your lordship, on the very
You want
day,
a stay?
my lord,
You want a stay? Do you want a stay?
my lord, thing is that, my lord, by disguise of this order, your lordship, the defendant, the respondent number 1, shall not disturb my position over the suitland, your lord.
They are
Now,
filing
what
objection.
happened, your lordship? In
They are
this
filing
case,
objection.
in this case, initially,
We'll have to hear them. They are filing objection.
no stay, my lord, our appeal has been dismissed, so no question of stay
They are
is there.
filing objection. Let us fix
Stay
it.
is not there, my. Now, my lord, what happened? My lord, an interim order was passed and thereby, my lord, learned trial court had granted final reliefs to the plaintiff. Whether this is possible under the law. And there has been left
Then they
nothing
filed
to be
objection with
decided in
their-
the court, my lord. Now, that question, my lord, is not being decided. What is the submissions of the lawyer not recorded?
It's
Lot of
okay.
judgments of the apex court was
So
filed
we
and
will
nothing.
hear
This is
you.
the case here, very unfortunate thing.
Learned Counsel, Mr. Endor
Yes.
is present for the appeal, for the petitioner. Learned Counsel, Mr.
It's Bora for
Bora
appearing on behalf of Mr. T. Mozumdar.
is present on behalf of Mr. T. Mozumdar, representing the respondent caveator. It is submitted by the learned counsel for the respondent that they will file that it is submitted, the learned counsel for the respondent has paid for time to file objection list the matter after puja vacation.
Yes.
And we file a caveat to likhi diwa, caveat is present, caveat is discharged.
I'm for respondent number 2 AP.
Learned Counsel, Mr.
B does one.
B Das is present for respondent number 2. Agordon for 1 meeting by respondent number 1.
Yes.
Always.
Hello, bless.
Yes.
Yeah, my lord. Here, my lord, by order dated 09/09/25, passed by the landed civil judge, Junior Division number 1, Nagaon.
I cannot hear you. Something is wrong with the speaker, I believe.
Oh,
Suffer speaker do.
speaker to sir. Okay, sir. Here in this case, my lord, I am challenging the order dated 9/9/2025, passed by the landed civil judge, Junior Division number 1, in title execution case 1 of 12. By the impugn order, my lord, one petition filed by my relative seeking an adjournment on my behalf was rejected. What happens in this case, my lord, my husband, he has filed an application before the executing court under section 47 of the CPC, challenging that the decree passed in TS number title suit is a nullity. And during the pendency of that execution proceeding, my husband expired. Thereafter, the
একো কাম দিয়া নাই স্পিকাৰটো। It's not working, I think. Yes, yes. Come to this side.
Yes, that is not working, my lord. So here in the execution case, my husband, late Santilal Jain, has filed an application under section 47 of CPC, challenging the decree passed in the suit that it is a nullity. During the pendency of that execution case, my husband expired. After his death, my advocate also informed the court that he has expired on such and such a date. Then under the law, the court should ask the decree holder to substitute the legal heirs of my husband. But the learned court, instead of substituting the legal heirs or directing the decree holder to take a step, issue a court notice directing that this court notice should be hanged up in the suit land or at my last residence. Though my husband was not residing, I am also not residing at Nagaon. I have left long before this Nagaon. Along with the application filed by my advocate on death certificate was also enclosed. In the death certificate, the address was shown at Gurgaon, Haryana. Clerical address was shown. Or moreover, when the court notice was hanged, one of my relatives was residing there. He informed me just one day before that this the court notice. Since I am a resident of Delhi, Gurgaon, I am not in a position to come. So my relative filed an application, but the court held that no, since he is not a party, not a decree holder, so his application is rejected. And decided that this application in my absence. Being aggrieved by that order, my lord, I have filed these applications before this honorable court that at least, my lord, an opportunity should have been given. When one of the legal heirs is coming before this court, one date should be given because I was ignorant about the process.
We'll have to read the order and then we'll have to read your prayer.
Yes, my lord. Yes, my lord. I am
Can you read the
at page 50, my lord.
Yes.
At page 50, my lord.
Yes.
My lord, first, my lord, I am reading, my lord. Beginning, decree holder is represented. Since the report submitted by the civil Nazir, in the report it is mentioned that the notice was duly affixed on 8/9/25 in the presence of the concerned landholder as directed by order 7/8/2025. The concerned processor is present and he is examined or oath as CW1 in separate seat, which is kept tanked with this case record. CW1 reports that on 8/9/25, he along with the concerned lot builder went to the suit land and the concerned lot builder identifies the suit land. CW1 further reports that he hung that notice in front of the suit land in front of bamboo pillar. It is also reported by CW1 that suit land is situated between Jain Bhavan and hardware shop. No legal errors or judgment letter number 1 and 2 appear
So
today.
according to you,
Ye-
that the judgment debtor has passed away, died.
Yes, judgment
And-
debtor past judgment debtor was my my father-in-law. He expired during the pendency of the suit. But in the suit itself, his legals have not been brought on record.
Okay,
So
the
when
suit legally has not been.
not
submitted.
be substituted. Thereafter, when I came to know about the execution proceeding, my husband filed the application under section 47 of CPC. But during that pendency of the execution case, my husband was also expired. Thereafter, on 5/5/2024, my husband expired. Thereafter, on 7/8/2025, information was also given to the court. Your lordship may come at page 33. At page
No, no,
30.
please read the entire order.
Entirely, yes, my lord.
Entire order.
Yes, my lord. No legal errors or judgment data 1 and 2 appear today. Since the petition number 245525 filed by one petitioner, Jeevan Bal Surana, praying for adjournment and fix another date after Puja vacation on the ground that the wife of Shantilal Duggar resides in New Delhi. In the petition, the petitioner stated that he is neither the decree holder nor a judgment debtor. The petitioner further mentioned that Shantilal Duggar was his relative. Heard the learned counsel for the petitioner, Jeevan Bal Surana. Considering the petitioner Jeevan Duggar is not a legal heir of judgment debtor, number 1, judgment number 2, petition number 2455 is rejected. That was the only the ground. Perusal of the case record show the instant execution case was instituted for execution of decree and judgment passed in TS number 82 of 06 on 9/11/2011. Proponent defendant number 6, Radhesham Agarwala, filed petition for stay of the execution. My lord, I think it is not relevant. One Radhesham Agarwala approached before this honorable court that his name should be struck off, and this honorable court has struck off that his name. So my lord may come, my lord, another page, my lord. Page number 52, last paragraph I am reading, my lord. And 52, my lord.
Yes.
I am reading, that is relevant, my lord. After 5 lines. The petition, but on the next page, on 7/3/13, petitioner Shantilal Duggar filed petition number 39 of 13 to dismiss the execution on the ground that the decree was nullity, as his father, the defendant number 2, expired during the pendency of suit, and his legal errors were not implemented in the main suit. The petitioner number so-and-so was rejected on 7/1/14 on the basis of hearing the parties and their evidence. Being aggrieved by that order, the petitioner Shantilal Duggar moved before the Honorable High Court. The Honorable High Court had order dated 3/11/22, passed in CRP IO 4/2014, directed the executive court to decide afresh as to whether the defendant number 2, Bhavanlal Duggar, had died before the decree was passed. If so, whether decree passed against a dead person can be executed against the legal heirs of the defendant number 2. Then the petitioner Shantilal filed the instant petition number so-and-so to pass necessary order in view of the order of the Honorable High Court. The decree holder submitted written objection on the ground that the summons was duly served upon the defendant number 2 in the main suit, but he did not come to contest the suit, and the instant is allowed only to cause delay. As per the order dated 3/11/22 of the Honorable High Court, passed so-and-so, this court now proceeded to decide the following points for determination. Whether the defendant number 2, Bhavanlal Duggar, had died before the decree was passed. If so, whether the decree passed against a dead person can be executed against the legal heirs of the defendant number 2. Point for determination, number 1, whether the defendant number 2, Bhavanlal Duggar, had died before the decree was passed. The evidence in chief on affidavit of the petitioner Shantilal Duggar as PW1 is on record, which was filed in connection with petition number 39 of 13 in this execution proceeding. Shantilal Duggar as PW1 deposed in his evidence in chief on a fact that he is the son of Bhavala Dugar, his father Bhavala Dugar died on 4/3/2009 at Sri B.D. Mehta Cardiac Hospital, Surat in Gujarat. PW1 exhibited copy of death certificate of Bhavala Dugar as Exhibit 1, which was proved in original by the Sarshidar Munshi number 1, Nagaon. To check the credibility of PW, he was cross-examined by the learned counsel for the decree holder. In his cross-examination, PW reported that he had not submitted any certificate of his. All these have been decided by this honorable court while deciding the CRP. So I think these are relating to the death. They have disputed that my father was not dead. He was not died on that. So all these have been decided by this honorable court. This honorable court remanded the matter, sent back the record only to decide 2 points: whether my father died during the pendency of the suit, and whether the decree can be executed against the legal heirs. So, my lord, this executing court, my lord, at page 57, my lord, the finding of this executing court, my lord. Second paragraph. In view of the above discussion, this court is of the opinion that decree passed in TS number can be executed against the legal or the defendant too, and therefore, keeping in view of the above and the order of the Honorable High Court dated so and so passed in so, the decree holder is directed to take a step for execution with regard to land cover by the number so and so. So that was the finding. Before that, my lord, the executive also came to finding that is also relevant at page 56, my lord, last paragraph. Perusal of the case record on main suit, that is TS number 82 of 06, and report the process server. So that summons was issued to the defendant number 2, Bhavala Dugar, several times, but he was not found at home. So summons was served upon him in such a manner by affixing a copy of the summons in his last residence. In the place, he carried on business. In the notice board of municipality board so and so on 020207, in the notice board of the court on 5207, in present witness. But the defendant number did not appear and should proceed at ex parte against him by the order dated 7507. The defendant number to remain absent did not file a denied estimate to conduct suit. Therefore, the judgment pronounced against him is valid and not nullity as per order 22, rule 44 SCP. As the judgment passed is valid and not nullity, it can be executed against the legal errors of the defendant number 2. That was the court's observation while passing the order dated 9/9/2025.
You are the JD?
I am the I am the applicant. I have filed as a petitioner. I am the son of my deceased father. I filed the petition before the executing court under section 47. The decree is nullity under section 47. The executing court has the power to decide whether decree is nullity or not. So when that proceeding was pending, my husband expired. So after his death, information was given to the court, but the court did not substitute the legal heirs of my husband. But even after having come to know about the court notice through one of the relative, I informed the court that a date may be fixed, let me given the opportunity to press my case. But the court has rejected that petition.
Which one?
That petition which has been filed by one of my relatives, that Your Honor may come at page number 43, my lord. Page number 43. That petition is there, my lord. A petition under order 21, rule 26 of CBC.
Okay.
Yeah. The petitioner most respectfully begs to state that the petitioner is neither a decree holder nor judgment debtor in the above notice, but on at 9/2025, just one day before, my lord. Next date was 9/9. The court notice hanged in the front side of a petitioner Jain Bhavan, which is not the subject matter of the decree. That apart from the court notice, it came to the knowledge of the petitioner that the legal representative of deceased judgment debtor number 1, Karni Dan Chajer, and deceased judgment debtor number 2, Santila Dugar, are directed to appear before the court on 9/9/2025. That late Santila Dugar was my relative. His wife Santosh Dugar is present, petitioner. Is now resident in New Delhi and Gurgaon, Haryana. Her name, address given hereunder. that your petitioner had connected with her study informed about the hanging of the court notice entitled execution case number 1 of 2012, that she requested me to inform the matter to the court pre-time for appearance of her also filed written objection in the above notice execution proceeding, that there is sufficient reason to stay the execution body because as per Honorable High Court, it was directed to the court where decree passed in spite of death of Santilal Jogar, the judgment in the original suit case number so and so. That your petitioner filed this petition just to adjourn the title execution on 1 of 2012 as per request of Santosh Jogar from New Delhi study, evening at 6 p.m. after received information from me about hanging of the court notice. That Santosh Jogar has no knowledge about the execution case 1 of 2012 in which he has interested in the suit, which is decreed against a dead person. The said decretal land belongs to Santilal Jogar and others, my lord.
What is your prayer in the petition?
My prayer, I am in my civil division petition, my lord. I have prayed, my lord. In that petition, my lord. In that petition, my lord, my prayer is, my lord. It is there, page 45. It is therefore that your honor would be pleased to adjourn the case today, fix another date after Puja vacation. Oh, my prayer, revision petition, yes, my lord. Revision petition by prayer, your lordships, may come at page 19. In the premises, as aforesaid, it is therefore prayed that your lordship would be graciously pleased to admit this revision petition and issue a rule calling upon the respondent as to why the order dated 9/9/2020 passed entitled execution number so and so by the learned civil judge Junior Nagaon should not be set aside. After hearing both the parties, we further pleased to make the rule absolute. Interim, my lord, pending disposal of civil division. Yes.
That also was decided ex parte against you.
That was decided ex parte, but no notice was served on the different notice because
been observed in that.
no, that was that's why I have challenged. Because when the suit was filed, my father left at Surat. He was not a
No,
resident.
we can't go there.
No,
We
my
can't do
lord,
execution
my lord,
case.
executing court can go, my lord.
No,
Under
there we won't go there.
there is also
It's already decided by the.
my lord, there is also the decision of the Supreme Court. I have received, my lord. Even the executing court can scrutinize. I can go to the details of the accommodation.
Writ has been issued.
Eh?
Writ has
My lord, directed to issue the writ. And next date is fixed on 25/9, my lord. So I have come before your lordship, my lord, that a procedure should be given to me, my lord, to see whether
This judgment, this is not required. I'll stay for only 1 month after vacation because,
yes, my lord.
but you do not have a case.
Let them appear, my lord. They will,
But it is delaying tactics. This is not good.
my lord.
This
My
is
lord,
not correct.
My lord, I will satisfy your lordship.
No, I'm not satisfied.
Because, my lord, when the applicant filed the application, at least matlaki, that petition should be disposed of. But I have died. My husband died. I have filed the application. So why the court did not incline to give me on that?
Mr. What is your name?
Samsati, my lord, R.C. Samsati.
R.C. Samsati is present for the petitioner who has filed his application under Article 226 of the Constitution of India. It is Constitution of India challenging the order dated 9/9/2025 passed in execution number 1 by the learned civil judge, Junior Division number 1, Nagaon. It is submitted that the petitioner is the legal heir.
Yes.
Is the legal heir of the deceased judgment debtor, JD. This is judgment debtor, within bracket JD for short, full stop. The petitioner has been prejudiced as the legal heirs of the judgment debtor has not been executed, has not been impleaded. Full stop. The legal heirs have not been accorded an opportunity to place their case. The order dated 9/9/2025 is a well-reasoned order, but for the interest of justice, only stay up to the next date is allowed. Stay of the proceedings, leader. Stay of the proceedings of title exhibition 1/2012 is allowed only up to the next date. List the matter on 16th October.
My lord, I shall not be here. I shall be out of station during Puja vacation after 16th October.
22nd October. Only on 22nd October. Meanwhile, issue notice to the respondents to place their objection against the order of stay as well as against the petition filed by the petitioners. Call for a scanned copies of the title exhibition case number, question unit case number.
Item 4.
Final, this is an revision petition. Lordship will get the order. That is on annexure 3 at page 47. In this case, there is a title suit was instituted by the plaintiff. There is a respondent. For compensation of 25 lakhs from me on account of he approached, suffered due to approaching 5 writ petition and as well as 1 contempt petition before the honorable court, challenging the certain order, impugn order that has been passed by the higher authority, that is the director and the commissioner to consult. So I was in party as a principal of the college, as an official respondent. Now, what happened? He might not file a title suit only in my personal capacity by his name, without including the other all official respondents. The reference was made to all the 5 cases and the 1 contempt cases where he had lost suffered due to approaching before the court. And on that issue, I filed a counterclaim along with the written statement, and preliminary issue was raised, non-joiner of necessary party. And accordingly, I filed 1 petition under order 19, rule 9 for maintaining this non-joiner of necessary party. Then the argument was heard, and I relied the judgment also, Lordship, where the Bombay High Court case and Kosturi case and Punam case, all where it is specifically stated who are the necessary party, without which implement no effective decree can be passed. So my submission was that if something is to be passed by the court, that the 25 lakhs, how I will be only in my personal capacity responsible. We are all officials. That is, the order is being passed by the official respondent, not by me. So I was being a principal, I have to oblige all the orders and comply the orders, whatever will be passed with the superior authority. So on that account, the honorable civil judge dismissed this petition. Although it is one side, she holds that a non-inclusion of the necessary parties, it is not a rule out that it cause some prejudice to the defendant. In spite of that, she said that may be decided in later stage and maybe the necessary party or may not be necessary. Accordingly, the petition was dismissed. So against that, I have filed with this revision petition. So my
where is the order?
Where is it? 47 is 11, that is 38.
Page 47.
Page 47 is started in the order. And the 11 person, and certain things were also perverse. He said that after hearing the objection filed by the other side, but they did not file in the objection. So so far the 11% is this. This is the page number that you will get at page 52. It is starting from last part of the 51, para number 8. Hence, after a care, got it, madam. Page number 51. Last part. Hence, after a careful observation of the pleadings and the ongoing discussion made above, it cannot be ruled out that the non-implement of the other officials by the plaintiff shall not cause any prejudice to the opposite party. So this is already whole.
I cannot find it. Page 52, which part?
It is a 51, Lordship.
51, okay.
Yes. Last part is a para number 8.
Okay.
It is starting. A careful observation of the pleadings and the ongoing discussion made above, it cannot be ruled out that the non-implement of the other officials by the plaintiff shall not cause any prejudice to the opposite party. But the other way, later on, And then, my lord, the besides of the instant suit, it may be precluded the court to pass any decree effectively, as implement can be made at any stage when the court feels it necessary for proper adjudication. This suit cannot be held bad for non-general necessary party, as a relief is specifically claimed from the main defendants. The other respondents may or may not be necessary parties to this instant suit, which can be decided at a later stage. In this reserve, the petition 1874 is accordingly rejected. My humble permission, my humble lordship, all the documents that is being relied by the plaintiff, it is from page number 13.
You are the plaintiff petitioner.
I am the defendant. I am the
You
sole
are
defendant. I am the Gulab Sharma Bora. I was the principal of that college. But in nowhere in earlier occasion, I was made as a in personal capacity made party in any of the institute. My lord. So, lordship, kindly come to page number 27. The document relied by the plaintiff. The first one.
Just a moment. Just a moment.
The lordship will get all the parties are official party, and I am the principal of the college as a pleaded as a respondent.
$874 is your petition.
My lord?
874.
Yes, my petition, yes. So my humble submission is, if something is to be decided, without their presence, how can it be decided that this has been done malafide or any illegality was done to him? Because the all order that is passed by the director, and in all the cases, the lordship will get these copies, and the order was passed by the honorable court, where it is always reflected, nowhere it is my name is there. As a principal, I was there, but not in personal capacity.
The title suit is 3 of 2025.
Yes, ma'am. Even the contempt, my lord, they rely, it is an annexer, I think, my lord, this is at page number 41, my lord. No. No. 41, 31. 30. Yes, my lord, page number 36. This is a contempt case where one, my lord, Kalyan Chakraborty and another, my lord, Dharmakanta Mili, they were the party. I was not in any party anywhere by name. And whatever I have discharged as being a principal of the college, I have to oblige, I have to.
Page number 36 is before this court, contempt case.
This is contempt also before this honorable court. So whatever he relied, all the 5-6 cases for which he
you are asking to be party in that title.
all this party, because the secretary, director, their governing body president is not party.
So here WPC in the where is your prayer in this case?
The prayer was, well, he was suffered, well, because of some departmental proceeding was going on. So he was, well, some penalty was imposed upon him for one reason. Another, well, he suffered because of promotion because of his non-complying of the superior authority's order. Then other all cases are the contempt case, non-complying of the honorable court order passed by this in this writ petition regarding his.
Can you read the prayer?
Yes, my lord. But this is prayer is starting from page number, my lord, 11. In this premises, lordship got it, my lord?
Yes.
In this premises, it is therefore prayed that honorable court may be pleased to admit this petition, call for the record, issue notices to the respondent, directing them to show cause as to why the prayer made herein for issuing of the writ of certiorari for. Oh no, my lord, this is, I'm sorry, my lord. This is my prayer, my lord. Lordship asked to pay my prayer. Yes, madam.
Your prayer.
Yes, madam. Call for the record, issue notices to the respondent, directing them to show cause as to why the prayer made herein for issuance of the writ certiorari for setting aside the quashing of the order dated passed by learned civil judge senior division Lakhimpur, rejecting the miss petition number 874 of 2025 in title suit number 3 of 25 should not be set aside in cause, and after entering the parties cause and causes being shown, and after hearing of the body say, we pleased to set aside and quash of the order dated 27 into 25, my lord. So this is my prayer. So my prayer is, my lord, without implementing this all the official director, this secretary, then this CB president, how this will be decided? Because they all are the necessary parties. And the necessary parties and the proper parties also, my lord, the Honorable Supreme Court
Is
is,
the plaint,
my lord,
plaint?
plaint, yes, my lord. Yes, my lord. Plaint is, my lord, is page number 15. It is started. And lordship, I will show you lordship. This is the, from para number 11, this is page number 20.
So you are the sole party.
I am the sole party, my lord. How that can be possible?
Just
And in the
give them a
plain, my lord, he has specifically stated the all the cases, number of the cases, and because of that cases he suffered. But what fall with me that he can come approach against me only by filing a title suit. So there also be necessary party because they were withheld because one of the reason they don't want to come with any conflict with the superior authority. This is the things. So they don't want to bring this is director, secretary because he knows better.
This
that
case is pending at which stage?
it is for last time that was for mutual compromise. Now it is for issuing documents. It is on 1510 is fixed. And there is a counter claim also from my side. I am Pramana at this stage matter will stay till matter will dispose of by lordship and notice revision by them. In earlier occasion, I write two decision also before the judge. One is my lord Bombay International case, another my lord the Mysore and the my lord Phnom case, and the custody that was not available, but custody was the basis of the all the cases, where it is specifically decided, and there is a two specific tests also there to decide the test number 1 and test number 2 to decide the court to who are the necessary party. In spite of all these things, that is not been reflected any single decision in the order also. So my humble that this matter be decided when this will be scrutinized by the honorable court, my lord. So it is a very in that case, my lord, I pray that this will state and this way.
Allegation is only directed against you. Why the others should be made party?
My lord.
Allegation is directed only against you. Why the others should be made a party?
My lord, I was not made a party as a principal, my lord, not as a my name. As a principal, because I am holding the post of the principal of the college where he is working as an assistant professor, associate professor. So that is why out of grievance and out of grudge, my lord, he has filed. This is the very from the all pleadings, it is clear because he should have come along with the other respondent also. But they are not made the party. Only I was the only party. Why it is there? Because in other cases, the principal is the only one of the official party, and the GB president also party. Director, secretary, commissioner of the education department, higher education, they were party. Now he trying to project it that because of this is my personal capacity, he suffered. But this is not the true things that can be decided. Because why these things has come after some departmental proceeding were drawn, and that is all been as following the all procedures of the disciplinary appeal rule. There is nothing to be done by from my side in personal capacity. So and GB also there. I cannot take any decision more from my side.
Issue notice.
But stay, my lord, I pray, my lord. But even
issue and documents next date.
no, issue document all right. My lord, what thing is that the issue, my lord, that to be scrutinized by your lordship. That is why I prayed because I relied my lord key decision also, my lord, lordship. Even lordship. Yes, my lord. This is
filed only against you.
me. Without impeding. They cannot be. And
No, but this is only direct allegation only against you.
against me. But
Confined only against you.
But we rely the document all the high court cases. Why he came, what was the order was passed. Nothing was there in my personal capacity, everything was done in my capacity in all the cases, my lord. There is no malafide allegation also against me.
I'll just go through the plain.
My lord. Plaint is very clear, my lord, where it is relied all the three cases, 4 cases. Plaint para number 11, it is started. And other than well, certain other allegation that cannot be decided in this suit. My appointment, my legality, how that can be decided in title suit, my lord?
No, he is not asking for any of that sort. He's asking only for damages, I think.
Damage,
What is
sir.
the prayer?
Damage, damage. How they can be blamed?
Created by you as a individual, not as a principal.
As a principal, whatever I did, that is as as a principal of the college. Because I have been directed by the director in some cases to take action against them and to forward the resolutions and everything. So I am the only carrying the things as per the direction was given. I have nothing to do anything from my side. If something is allegation has come against the began by administrative office head of the department in his college, I have to take the action. For that, I cannot be blamed for personally. If it is something to be done, they have to be made party in this case. Because from para 11 to onwards, your lordship will get all where it is saying that all the 5 cases why it has been approached and where nothing has been malafide against me. Being a
Just a moment, I'll just read the plaint and the counterclaim.
yes, yes. Counterclaim is not there, but
You
my
stated that you have a counterclaim.
I have filed a counterclaim there, but this is not annexed here.
No, then how can I state?
And my this is petition order 1, rule 9 is very clear. And if the lordship will want, then I can provide the counterclaim also, but then better be in the next Monday.
No, not next Monday. This is at the motion stage.
Motion stage, yes.
Okay, then yes, next Monday, not Monday, Tuesday.
Oh, my. Should I file in a way of additional affidavit or I can provide to lordship? I file.
Additional affidavit
I'll
will be better.
I'll
But this bench will not be sitting next Tuesday.
my lord.
Some other will be there, so additional affidavit will be better. You take back this, I think.
I'll take, well, I'll fund this all this.
Yes. Learned Counsel Mr. P. Mohanto is present for the petitioner. List this matter on Tuesday, 23rd.
Item 5.
ইনফ্লোছিলে নম্বৰ 95 আপোনাৰ নহয় নেকি আপোনাৰ কিমান আছে 4 নহয় নেকি ফাইভ টো বেলেগ হয় নেক্সট গ্ৰুপটো ফাইভ আপোনাৰ নহয়
That day I was about to pass an order.
My lord has already recorded it, my lord. Today, we have filed an IA also, my lord, for correction in the cross tagging, my lord. It has come with this in the supplementary list as connected item.
As an idiot.
Supply 42, my lord. Supplementary list 42.
I have forgotten the story.
My lord, I will narrate it again, my lord. My lord, there was an application for amendment of plaint, my lord, by the plaintiffs.
Change the nature.
Yes,
Okay.
my lord, the plaintiffs were evicted from
You
the,
just draw my attention to the relevant parts. I'll pass the order.
my lord.
To IA to.
My lord, prayer for amendment was made, my lord. My lord, I am drawing my attention to, my lord's attention to paragraph 49. Page 40.
Let us first dispose of the IO.
Yes, my lord.
Then maybe we can fix a date next week. As part and matter.
My lord has already recorded the order, my lord. I think
No,
my lord has passed this stay also. My lord has directed the steno to keep the part recorded. That's why my lord has fixed it today. That was already dictated, my lord. The order was dictated by my lord, and my lord has said that you file an IA immediately. That's why, my lord, we file on the same date.
Dictate kora sai. Nivedita asal niki. Dictate korisilu kisa order.
The order was.
Oh. Any recording থাকিব না? Dictate কৰাটো. 79 recording of side lolo without কি dictate করলো বেশি নাই করা So let us dispose of the IA first and
Well.
I will pass complete the order.
My lord. My lord, in the IG, my lord will see paragraph 3.
CGC.
My
Part
lord.
CGC, Mr. H. Gupta for the applicant. Who applicants
Applicants, my lord.
or one
Applicants, my lord.
applicants number 1, 2, and 3 who have filed this application with prayer for correction of the details of respondents 14, 15, 14 and 15. And to change the nomenclature as the deputy commissioner as the deputy commissioner Kamrup.
As Deputy Commissioner Kamrup, my lord.
Uh,
Paragraph 3.
Earlier you have added them as
Earlier it was Deputy Commissioner Sonitpur, Tezpur.
okay. Deputy Commissioner Kamrup instead of Deputy Commissioner Sonitpur Tezpur. Kamrup M Guwahati. And the
Circle officer.
And the respondent number 15 to be the nomenclature of the respondent number 15 to be corrected as the circle officer Guwahati Revenue Circle District Kamrup M instead of circle officer
Dekia Juli.
Kiajuli. It was asking in order to dictate code for asking.
Order was. Order to dictate ho gaya tha. My lord, the order was dictated. My lord has directed the steno to keep that part. If my lord, I don't know.
Who asking?
Oh, last steno, my lord. 17.
Yes, yes, I remember some. Nivedita aslo. ঠিক আছে.
My lord has also granted the stay, but subject to, my lord, this correction was there, so my lord asked to file the IA and then come today.
Nivedita, okay, I'll pass the order.
My lord.
I remember you have drawn my attention to certain paragraphs.
Certain paragraph of the plain and
And
then.
I have noted down the page numbers and we have the index also.
Yes,
Oh,
yes.
it's another.
My lord.
I'll grant the state.
My lord, my lord. Oblige.
I to Nivedita Gidiva type করবে। দুবার type করবে না।
Oblige.
Item 6.
Made please. Okay, this revision is preferred against the order dated 10/9/2025. Lordship. That is Annexure 6, page 26.
Page 26.
Page 26.
Yes, please read the order.
Lordship, it is noted that except the land and acquired for National Highway, position of the remaining part of decretal land and was handed over to decree holder as shown by Latmondal after field verification and measurement.
This is the impugned order.
This is the impugned order.
Okay. Yes, what is your grievance? You are the other one
Other one,
who
okay.
was not given
Here,
the
The decree was passed at two-third of the lordship, the preliminary decree is at page,
You're for Anjumani doctor.
yes, Lord.
So little, 1/3 is now kept attached,
Attached, Lord.
not handed over to you.
Yes, Lord. Here the decree is passed on order annexure 1 page 12, Lord.
Page 24.
Annexure 1 page 13 is the main page, annexure 1 page 12 is the decree. Lord. Page 13 is the order.
No, you are agreed by only this attachment.
Yes, attachment. Lord. Because the court cannot go beyond the decree, Lordship. The decree is very much clear, Lordship, in that plaintiffs are entitled to two-third their share of the suit property.
There is a provision to file a petition in the court itself. There's a provision to file a petition in the court itself under order 21. Rule, I think I can show you the rule also. So what, you are coming straight away before the High Court?
High Court.
Under 227.
227.
Where is the decree?
Decree is at page 13, Lord. Operative portion at page 13.
It is correctly attached.
Lordship, here it is written that plaintiffs are entitled to two-thirds
Yes.
share of the suit property, Lordship.
Yes, it is correctly attached.
Lordship, that is beyond the decree. Lordship, decree is clear, Lordship. Unless and until the decree is modified or
See, as the plaintiffs are entitled to 2/3, so only 1/3 is attached.
yes, Lord.
2/3 is given handed over to you. I do not find any wrong in this order. Or do not, no, I do not find any error in this order.
Lordship,
See,
Lordship, here the two-third is given again, Lordship, next last para, Lordship. 1/3 of the share of decree holder has been addressed.
yes,
Last
1/3 because you are,
Decree holder land has been attached, Lordship. Let a decree is clear, Lordship. Two-third of the plaintiffs are entitled to two-third of the suit property. Lord. That is the decree holder, Lord. Plaintiff decree holder.
after the title suit, you have not preferred any appeal.
Lordship, the other side has preferred an appeal.
But the appeal was dismissed.
Not dismissed.
You are Anjumani doctor and Premolata Soikia.
Yes.
And the Ojit doctor has preferred an appeal.
Appeal, Lordship.
So on this order of the title suit, the decretal land was apportioned.
Yes, Lordship.
Your brothers, sisters, brothers and sisters.
Brothers and sisters. Mother's brother and sister.
No, it's correct. Correctly apportioned. 1/3 length of decree holder Premolota Sekar was inadvertently handed over to DH number 2, Anjumani Datta. So this 1/3 is attached.
Yes, Lord.
2/3 has been handed over to you.
No, Lord. That attachment is made on that 2/3, Lord. The defendant land is not attached, Lord. That means judgment debtor lands has not been attached, Lord. 2/3, it is 1/3 that is part of the 2/3, Lord. 2/3 share.
Where is the judgment and order?
That is order, preliminary decree is at 13, Lord. Page 13.
Not decree, judgment and order.
Final decree is Lordship at page 16, Lordship.
I don't know, I cannot see any error. Cannot find any error.
Lordship, 2/3, the decree holder gets 2/3, Lordship. That is the plaintiff decree holder gets 2/3, Lordship. Here,
CPC on there. So both the plaintiffs got 2/3 and the defendant got 1/3.
1/3. Now 1/3 portion of the plaintiff lands has been attached. That is decree holder's land has been attached, Lordship.
Because the entire land was handed over to the plaintiff.
No, not the entire land, Lordship. 2/3 land was handed over.
But here in this order, you say,
Entire land not handed over, Lordship.
peruse the case record, it appears that there are 2 decree holders in this case. However, learned counsel for the DH has taken steps on a possessory warrant only in the name of one DH, namely Srimati Anjumani Datta, for which the entire land was handed over to the DH number 2 Anjumani Datta, which is not in accordance with the decree.
But the they both are plaintiffs, Lordship.
Yes, okay.
These
It's
both are
okay.
plaintiffs, Lordship.
Yes.
Lordship,
Both
annexure 4, page 20.
handed over. I cannot find any error in this order. What to do? You take it up on some other day. Okay? Next week. This matter on Mr. S.
J. Sharma.
S. J. Sharma is present for the petitioner. List this letter on 25th September.
May it please the lordship. Second round of litigation, madam. What had happened, madam? The respondent number 2 was one of our contractors. We are a central public sector undertaking. Certain disputes arose between us. There are pending arbitrations. Now, in the meantime, the respondent number 1 filed a suit against the respondent number 2. Suit was decreed. We were not parties in that, madam. Now, the respondent number 2 had certain machineries in our campus, madam. That was attached. Now, there was an order passed on 21/6/2025, my lord. Lordship finds that at page 110, my lord. By that order, my lord, a writ of attachment was issued and the civil nazir was directed to execute the writ, my lord. Lordship finds the operative part at page 112, my lord. My petition was rejected and last portion, my lord, civil nazir is directed to execute the writ and submit the report on the next.
Okay.
Now, in the meantime, what had happened, my lord, there was a proceeding against the respondent number 2 before the NCLT under the IBC code, IBC, my lord. Their moratorium was declared and the ultimately resolution plan was passed. The present claim, which is the subject matter of the suit, my lord, that was not included. And there are judgments of the Supreme Court which says that once the resolution plan is approved, my lord, everything is final, crystallized. Other than what is there in the resolution plan cannot be executed now. So that became an inexecutable decree. Now, raising those issues, my lord, I had filed an application before the executing court. Without deciding that, my lord, this order was passed, I came up before this honorable court, my lord. And this honorable court, by order dated 7/8, Lordship finds it at page 121. This order dated 21/6 was set aside. Operative portion, my lord, may I read this order, my lord?
Yes.
Heard Mr. Hendekel under counsel in this petition under Article 227 of the Constitution, the petitioner has challenged the order dated 21/6/2025 passed by the learned civil judge in money execution number so and so. It is to be noted here that while the impugn order dated so and so, the learned civil judge so and so had directed the civil nazir to execute the writ and submit a report fixing the matter today, that is 7/8. Mr. Tekal and counsel for the petitioner, by referring to the judgment and decree dated 26/7, submits that the present petitioner is not a party in money suit number 31, instituted by FJ Trading, respondent number 1 herein, against Jai Hind Projects, respondent number 2 herein. And in the said suit, the civil judge Dibrugarh had decreed the suit, making the defendants so and so and 2 others liable to pay a sum of rupees 21 lakhs with interest at the rate of so and so.
Brahmaputra.
No, Brahmaputra is not a party.
Brahmaputra was not a party.
Not a party. That is what
But
is.
you are a petitioner here.
I am a petitioner because now.
Because you are asked to pay the compensation.
No, I am not asked to pay the compensation, my lord. Some of their materials are lying in our compound. There is a dispute between them, that party and us. Arbitrations are pending. Now those properties are being sought to be attached. Now lordship comes to the operative part, my lord, at page 124. Paragraph 6, my lord. Indisputably, lordship gets it. Indisputably, the present petitioner is not a party to the above proceeding. It also appears that taking such a stand and also mentioning about the moratorium imposed under section 14 of the Insolvency Code in so and so proceedings, a petition number 114 of 2025 has been filed before the learned executing court, but the same has not yet been attended to by the executing court. Instead, it has directed the civil nazir to execute the writ and submit the report on 7/8. Next page, ma'am. Under such circumstances, the impugn order dated 21/6 appears to be illegal and arbitrary, and accordingly, the same is interfered with. The learned executing court is directed to hear the parties on the petition number so and so, and thereafter to pass a reasoned order. Well, at the moment I submitted this order, the learned court below has issued contempt notice against me. I have come against that. Lordship kindly takes up the impugn order. Before that, my lord, kindly turn to page 126. On 7/7, the case was fixed. The learned court below was pleased to fix the matter on Monday, 22nd of September. Now the case records when this order was passed by this honorable court, on the next day the matter was placed. This is the order passed, Case record put up before me, seen the judgment order of Honorable Guwahati High Court in CRP so and so, whereby the order dated so and so appears to be, this is a typing mistake, it should be illegal and arbitrary. And accordingly, the same is interfered with, and with this court is directed to hear petition number so and so. Accordingly, both sides are directed to remain present for hearing. I have got no objection on this matter. Now, Lordship comes to page 135. Later on, my lord, this is again taken up. Later on, a report dated so and so was received from Civil Nazir, whereby so and so he along with he records everything, my lord. And lastly, at page 137, at 137, it is recorded from the middle paragraph, my lord. On perusal of the case record, it appears that on earlier occasion also, BCPL had obstructed execution of restraining order dated so and so. I can show these orders, my lord. 28/6 was the order when notice was issued to me. How can I prevent the execution? Then, my lord, in such a situation, it appears that BCPL is willfully obstructing Civil Nazir on several occasions in spite of repeated directions for restricting such obstruction. Hence, Civil Manager, Security and Senior Manager, the petition numbers 2 and 3 before your lordships, now, my lord, are directed to show cause why the matter should not be referred for drawing proceedings of contempt. My lord, the order which is set aside by this honorable court by holding is illegal and arbitrary. Now I am being drawn up for contempt, my lord, for violating the said order. With utmost respect. Let the proceeding go on, my lord. I have no difficulty. Let the hearing be concluded. Only the show cause may be stayed, my lord. And here, my lord, most interestingly, the party has not come up claiming violation. It is the court on its own motion which takes it up. No application is filed by anyone. The judgment debtor or the decree holder is not coming up with a petition that there has been violation, issue contempt notices. The court takes it up suo motu, my lord.
Have you analyzed these orders? 28/6,
Yes, yes, ma'am. 28/6 order is at page 95. Lordship has seen, I am not a party. Now 28/6, Lordship kindly turns to page 95. Decree holder is present. Peruse the report dated so and so submitted by the Nazir of this court, wherein it is stated that the object which was supposed to be attached by the court was lying in the compound of BCPL. Also, it is stated in the report that the permission of Chief Operating Officer is necessary for executing the warrant issued by the court. Also, peruse the copy of written statement submitted by the judgment debtor in the execution case. In view of the above, I deem it fit to hear the version of Chief Operating Officer as well as Security Officer and also the judgment debtor, namely Jai Hind so and so. As such, the personal appearance of aforesaid individuals is necessary before the court. Fixed on 3/8. Now 3/8 order is at next page, madam.
Okay.
Decree holder is duly represented. The manager legal on behalf of BCPL has appeared and has provided her explanation with respect to the inconvenience caused to the executing officer who has approached this BCPL in connection with execution of the decree. The manager legal is directed to place the say of BCPL, if any, in connection with the attachment of movable property and removable so and so, fix so and so for passing necessary. Where is the violation from these two orders, madam? I fail to understand, madam. On 28/6, my appearance is directed. I appear. I say I want to file a written objection. That is allowed. Then that order of 21/6 comes, my lord. This honorable court interferes. Matter is remanded. You hear the objection first. I have got no objection, my lord. Let that objection be heard. But putting a sword of contempt over my head, my lord. And when this honorable court has held that the issuance of the writ was illegal and arbitrary, my lord, in that view of the matter, can the learned executing court suo motu take up a contempt petition with utmost respect? And for that, my lord, I'll be relying on a judgment of the Supreme Court, my lord, 2015 1 SCC page 451. Here it was a case of contempt against the company law board. The apex court held that company law board is a court which is subordinate to the High Court. And there is no provision for execution of orders passed by the company law board. So lordship can,
See, what I understand is, the court doesn't mean contempt before that court. Contempt.
cannot be before the court.
Against the order of this High Court.
No, my lord. Contempt for violated. Man, what order of the High Court have I violated, my lord?
That is what is written in the order.
No, my lord. 28(6) is his order. Trial court's
You
order.
see, this order, drawing up a contempt proceeding is on page,
Page 135.
you see.
Yes.
Hence, the chief manager and senior manager of BCPL are directed to show cause why matters should not be referred to Honorable Guwahati High Court for drawing proceeding of contempt of this court. Okay. Of
For
this
which
court.
order, man? Violating which order? Because the lower court does not have the power to draw up contempt.
No.
The matter has to be referred to the High Court under section 10 of the Contempt of Court Act. Man, which order of the High Court have I violated, my lord? If your lordship reads the order, the entire order, my lord, the just order above that. In such situation, it appears that BCPL is willfully obstructing civil nazir. That is why the contempt. There is no question of violating because it is I who have approached the High Court, my lord. The High Court has ordered in my favor. Where is the question of me violating the order of the High Court, my lord? And if, my lord, let us assume, my lord, the High Court's order is not there. Suppose someone violates the order of attachment of a writ, my lord. There are remedies available under the CPC. That is what, my lord, the judgment which I have handed over to your lordships. Kindly take up paragraph 28 of that, my lord.
I'll come back after 5 minutes.
Right.
Taken about that order?
The judgment, my lord.
No. That order to issue a show cause or draft
Yes,
up a
page
contempt.
starts at 135.
Please, one, please.
Second last paragraph. The ground on which it is issued that I have willfully obstructed the civil nazir from
Okay,
executing.
I'll send it back. Not to draw a contempt, but pass it, not to draw a contempt proceeding.
Not to draw up.
Okay, I'll pass it. What is the point of staying? Because there is no contempt proceeding has not been drawn up. Only a show cause has
That is
been.
what I am apprehending, my lord.
Mm.
Because the very order on the basis of which it has been passed,
Mm.
that has been set aside by the High Court. Not as of today, my lord, there is no order on the violation of which is alleged, my lord.
Mm.
Lordship may set aside the order and remand the matter that let the matter be heard as per the earlier of the order of the High Court, my lord. Because the Honorable High Court, my lord, at page 121 has directed the Learned Executing Court to hear my petition filed on 4/1, petition number 114 of 2025.
Mm.
That petition is at page 97. So let the trial court proceed with the hearing of this petition, and in the meantime, my lord, that contempt proceeding should not be drawn up.
You relying on which?
Paragraph 28, my lord. If your lordship takes up 465 page number. At the top, my lord.
Mhm.
As such, in normal circumstances, a decree holder cannot take recourse of the Contempt of Courts Act
Paragraph 28.
Paragraph 28, my lord, page 465, I am reading.
Okay.
Lordship may read 28 also. The present case relates to civil contempt. The present case relates to civil contempt wherein an undertaking given to the company law board is breached. Normally, the general provisions made under the Contempt of Courts Act are not invoked by the High Courts for forcing a party to obey orders passed by its subordinate courts, for the simple reason that there are provisions contained in the CPC to get executed in its orders and decrees. It is settled principle of law that where there are special laws and general law, the provisions of special law would prevail over general law. As such, in normal circumstances, a decree holder cannot take recourse of the Contempt of Court Act, else it is sure to throw open the floodgate of litigation under contempt jurisdiction. It is not the object of the Contempt of Courts Act to make decree holders rush to the High Court simply for the reason that the decree passed by the subordinate court is not obeyed. However, there is no such procedure prescribed to execute the order of the CLBs. That is a different issue under the company law. So, for executing a decree, the Contempt of Court Act cannot be resorted, which is sought to be done.
What is your prayer in the petition?
My prayer is to set aside the order, my lord. Prayer at page 27. My prayer is to set aside the order dated 8/8/2025.
Our learned counsel, Mr.
N. Decker.
N. Decker, for the petitioners. Who have filed this application under Article 227 of the Constitution of India with prayer to set aside the order dated 8/8/2025 passed by the Learned Civil Judge Senior Division, Dibrugarh, in money execution case number 3 of 2019. It is submitted that the petitioners are apprehending that a contempt proceeding may be drawn up as has been mentioned in the impugned order, full stop. It is further submitted that the petitioners were not parties
In the original suit.
in the original suit, being what title?
Being title suit number, I'm just giving the numbers. Title suit number 31 of 2015.
Title suit number 31 of 2015. In from which the money execution 3 of 2000 of 3 of 2019 has originated.
Yes, ma'am.
It is submitted by order dated where is High Court's order?
High Court's order is at page, my lord, 1.
Okay, by order dated by the
21.
in CRP within bracket IO bracket close 309 stroke 2025 in connection with Brahmaputra Cracker and Polymer Limited versus MSFJ Trading Company and another. The order of the Learned Civil Judge Senior Division dated 21/6/2025 was set aside, directing the court to hear the parties on petition number 114/2025 dated 14/1/2025.
4/1. 4/1.
4/1/2025. Thereafter, this impugned order was
Therefore,
passed. Thereafter, this impugned order dated
8/8.
8/8/2025 was passed. Page number?
Page number 135.
Full stop. It was observed by the court that a report dated 7/8/2025 was received from the civil Nazir, and he, along with the process server on 6/8/2025 had earlier visited the site. Full stop. The representative of the decree holder along with 7 laborers were present at the site. But the officers of CISF and BCPL refused to issue pass to the laborers and the vehicles in entering into the premises, as they did not receive any email from the head of security department. Permission was not accorded to remove the scrap materials from the campus of the BCPL. Full stop. Later, at 3:30 p.m., were allowed to remove the scrap material from the premises of the BCPA. But again, when the DH along with the process server arrived at the main entrance, they were kept waiting by the CISF personnel till 4:15 p.m. as the security force officers did not receive any email from the security department. Full stop. There are next pair, continue with italics of liquidity, order by it was observed by the court head of italics of liquidity. Again on 7/8/2000 p.m., the DH along with the Nazir visited the site visited the site. DH, the Nazir along with to 25 laborers, 4 trailers, 3 hydra and 2 cranes went to the site to remove the scrap materials. Full stop. They reached the spot at about 10:25 a.m. But at 11 a.m., the court staff were allowed to enter the premises, whereas the laborers were not permitted to enter the site. It will be, it will be difficult to execute the decree. If they, every day they will go with laborers, tank and all that, then they will say for this reason or that reason.
That is what decree cannot be executed. It is an inexecutable decree. That is what I have raised in my petition under 114. That is what the Honorable High Court has directed, that you decide the issue first, then go for execution. Lordship will kindly come to the High Court's order, my lord. Kindly for a moment. Page 123, my lord.
123. So we'll have to read the order, complete order then. 123.
It's short order, my lord.
Yes. We can read it.
Yes, from the beginning.
Yeah, it would be better.
Okay, ma'am. I'm reading for the beginning. From paragraph 4, I am reading, madam. Now from paragraph 3.
Yes, paragraph 4, it will be fine.
Paragraph 4. Mr. Decca has, by referring to the judgment and decree dated 26/7/18, submits that the present petitioner is not a party in money suit number 31, instead instituted by FJ Trading against Jai Hind Projects, and in the said suit, the learned civil judge Dibrugarh had decreed the suit, making the defendants Jai Hind Projects and 2 others liable to pay a sum of rupees 21 lakhs with interest till realization, and also to realize the entire amount of scrap materials and any other properties belonging to the defendant company and kept in the BCPL Dibrugarh and cost of the suit. Mr. Decca also submits that thereafter one money execution case being so and so was instituted, and the said execution proceedings wide impugned order dated 21/6, the learned executing court had directed the civil Nazir to execute the writ and submit the report on the next date, that is 7/8. Mr. Decca further submits that on 4/1/2025, this is the crux, my lord, on 4/1/2025, in the said execution proceedings, the petitioner had filed one petition mentioning clearly that the petitioner is not a party to the dispute between FJ Trading and Jai Hind, and hence the petitioner has no knowledge of the money suit number so and so. Mr. Decca has also pointed out that Jai Hind Projects Limited herein was awarded 6 contracts for mechanical and piping jobs and some units of BCPL so and so, and the value of the contract was 217 crores. And thereafter, Jai Hind Projects herein had invoked arbitration proceedings against BCPL for disputes arising out of the 6 contracts in the year 2015. And the claim of Jai Hind Projects was rupees so and so, wherein the present petitioner also lodged his counterclaims against Jai Hind, and counterclaim of the petitioner was 56 crores and all. And that in the meantime, Jai Hind Projects Limited went under corporate insolvency resolution proceedings, and the arbitrations halted on account of moratorium imposed under section 14 of the Insolvency and NCLT, 14 of the Insolvency Code, and NCLT Ahmedabad, wide order dated 19/3, approved the resolution plan of one so and so. Mr. Decca submits that the petitioner had registered its claim against Jai Hind amounting to rupees so and so with the resolution professional of Jai Hind Projects by calculating the counterclaim and interest thereupon up to so and so. And an additional claim of rupees so and so was also lodged towards workman dues and contract workers of Jai Hind. And the NCLT Ahmedabad, by order dated so and so, directed the resolution professional of Jai Hind to lodge the claim of BCPL at its full value. Mr. Decca further submits that mentioning the aforesaid facts, the petitioner herein had filed a petition being petition number 114 of 2025, dated 4/1/25 before the learned executing court, and the learned executing court had acknowledged receipt of the said application by order dated 8/4/2025. But the said petition is yet to be disposed of by the learned executing court, and without disposing of the said petition by the impugned order dated 21/6, the learned executing court had directed the civil Nazir to execute writ and submit the report. And in view of the aforementioned facts and circumstances, the impugned order dated 21/6 is arbitrary and illegal, and as such, the same may be set aside. Mr. Decca submits that in view of moratorium so imposed under section 14 of the Insolvency Code, the civil court has no jurisdiction to proceed against the judgment debtor, and therefore it is contended to set aside the impugned order and to direct the learned executing court to hear the parties and dispose of the petition number so and so before proceeding further. Having heard the submissions, learned counsel for the petitioner have carefully gone through the petition and documents placed on record, and also perused the impugned order dated 21/6 and judgment and decree dated so and so passed in money suit so and so. Indisputably, the petitioner is not a party in the above proceeding. It also appears that taking such a stand and also mentioning about the moratorium imposed under section 14 of the Insolvency Code by the NCLT Ahmedabad in insolvency resolution process proceedings, a petition number 114 has been filed before the executing court, but the same has not yet been attended to by the executing court. Instead, it has directed the civil Nazir to execute the writ and submit the report on 7/8. Under such circumstances, the impugn order dated 21/6 appears to be illegal and arbitrary, and accordingly, the same is interfered with. The learned executing court is directed to hear the petition on petition number so and so, and thereafter to pass a reasoned order. Now, the issue is that the moment this petition is considered, my lord, the decree will become inexecutable. They cannot execute the decree. That is why this honorable court has directed that hear that first, then go for the subsequent process. Now, because the order has been set aside, notice of contempt has been issued against me, my lord.
Where is the order dated 21/6?
That is the order, my lord. Page 110. May I read, madam?
Not
The-
required. Oh, that petition number 114 was filed on?
Petition number 41, madam. Petition number 41 is at page 97.
Not 41, it's petition number
4125. It was filed on
1144.
Yes, 4125.
Was filed on?
4125.
It's pending.
It is still pending. That is what has been directed, my lord, to be disposed of.
Okay. It was also observed by the court that on perusal of the case record, on earlier occasions, the BCPL, it is discernible here on perusal of the case record, comma, it is discernible that on earlier occasions also the BCPL has obstructed execution by restraining civil Nazir, which is reflected in the orders dated 28/6/2024 and 3/8/2024. The petitioner has drawn the attention of this court to the orders dated 28/6/2024 and 3/8/2024 marked as annexures.
Page 95. And 96. Annexure G and H.
Annexure G and H of the
No, no, annexure G only, madam.
Annexure G of the petition, comma, which clearly reflects that no which clearly reveals that no obstruction of the BCPL has been reflected in the aforementioned orders dated 28/6/2024 and 3/8/2024. I have also scrutinized the annexure G, which includes the orders dated 28/6/2024 and 3/8/2024. This court in CRP IO 309/2025 has directed while order dated 7/8/2025 to hear the petition 114/2025 dated
4/1/2025
and thereafter has directed the court to pass a reasoned order and to proceed with the matter further, comma, but the petition number 114/2025 dated 4/1/2025 has not been taken up by the court, and the court proceeded with the execution without deciding the petition number 114/2025 dated 4/1/2025 in violation of the order of this court dated 7/8/2025 in connection with CRP within bracket IO bracket plus 309/2025. It was also observed by this court in para 6 of the order dated 7/8/2025 that the executing court, instead of disposing of the petition number 114 of 2025, directed the civil Nazi to execute the writ and submit report on 7/8/2025. It appears that considering the submission with circumspection, the executing court is hereby directed after considering the with circumspection, I have given my thoughtful considerations to the submission at the bar. The executing court is hereby directed to comply with the order of this court dated 7/8/2025 in connection with CR3
IO
309 of 2025 and dispose, and here the parties on petition number 114 of 2025 dated 4/1/2025 before proceeding with the execution.
Yes.
Before
And
proceeding with the execution.
contempt should be not proceeded with.
The court is also directed not to proceed I have also the court has, the learned counsel for the petitioner has also relied on the decision of the Honorable Supreme Court in E. Bipanaya versus T.S. Raju and others within bracket 2015 1 SCC 451, wherein it has been held that paragraph 28 last line eta ase moi pencil di kati disu he line to bharabo na lage ha paragraph 28 gute to bharabo pencil di kati line to na lage italics of bhariya within inverted commas. The petitioner is apprehending that a contempt proceeding may be drawn against the petitioner as they are directed to show cause why the matter should not be referred to this court for drawing proceeding of contempt on the next date fixed, full stop. It appears that at this juncture, as the parties are willing to, as the petitioner is willing to place his submission on petition number 114/2025, any contempt proceeding is not required to be drawn up or notice show cause is not required to be issued as to why contempt proceeding is not to be drawn up, full stop. Thereby, the order relating to issuance of show cause, the order dated, well, set aside the order.
Yes, madam.
The order dated 8/8/2025 is set aside. And the parties are directed to, and the court is executed, set aside, and at present, the court is directed to initially dispose of the petition number 114 of 2025 dated 4/1/2025 and thereafter proceed as per law.
Yes, madam. Apply.
This order may not affect the merits of the case. This order will not affect the merits of the proceeding.
Yes.
Execution proceeding.
Apply.
In terms of the above observation, this petition stands disposed of.
Item 8.
Your Lordship, may this matter be taken up after some time as my senior is in legs in another court?
Okay.
I leave it.
Item 9.
And Bodamiller KVA also. Respondent number 2.
May I please, Your Lordship? Instant petition
between the same family, brothers and sisters. And it's a partition suit and cancellation of certification. I am the present petitioner is dependent, present and against the petitioner.
Parties are present.
No, oh yes. My lord,
So we'll
please
fix it
debate.
for, all the parties are present, then we fix it for hearing day.
But maybe, but then.
I am for the respondent number 2.
Only respond number 2. What about the others?
Well, I have no instructions, my lord, on that.
You are the caveator for respondent number 2.
I am for the, only for the respondent number 2.
There's an IA also?
Yes.
Okay.
But I have an objection, my lord, in regard to my lord staying.
No, yes, I'm fair because impugnator my lord may be Piroj. Impugnator at page 70. There are two impugnator. Order date 2/7/2025 and order date 4/9/2025. First order date 2/7/2025 and Annexure 6 page 70.
Annexure 6 page 70.
70.
Page 17.
70.
Oh,
Annexure 6. The cross exemption of PW1 closed. Dispense with. And subsequently, the DWR also closed.
You are for the defendant?
Defendant.
Okay, cross-examination of PW1 has been closed.
Closed.
And DW's also has been closed.
DW has neglected DW fixed and then took time by the learned counsel and DW also closed and the exit fixed 22 for argument. That's why stay is required. Well, otherwise my petition will impact us.
My lord, if he completes, madam. Lord, if the conduct
If you
of the.
send it back and then we will allow them to cross-examine PW.
No, my lord, I have objection, my lord, because my lord, my lord, their conduct, my lord, their conduct is very bad, my lord. And my lord, my lord, if when their conduct is bad in conducting the case, my lord, they have to face the consequences, my lord. There is no option left, my lord. Because, my lord, there is a, my lord, clear, my lord, while, my lord, the court has passed the very reasoned order, my lord. If your lordship peruse the order dated, my lord, 2/7/2025, your lordship will find, my lord, may I read, my lord. My lord, page 70, my lord. On date 2/7, plaintiff number 2 is represented. Defendant are represented. One PW, namely so and so, is present. That is the respondent number 2. Today, the case is fixed for hearing on petition number so and so, cross-examination of PWs, cause necessary order. Here they are projecting this case by saying that this case is not on that particular day, 2/7/2025. The case was not posted for cross-examination. They have projected in that way. But it was for the cross-examination of PWs, cause necessary order, and also for hearing. My lord, I am reading the third line, my lord. The engaged counsel for the defendant, Bhait petition number 1550 of 2025, has prayed for another date for hearing as the concerned senior counsel has been suffering from severe back pain. No medical document is enclosed with the petition. Peruse the case record. On such perusal, it has been seen that, my lord, this is may kindly mark, my lord. The engaged counsel for the defendant had repeatedly taken adjournment on 24/9/2024, 18/11/2024, 18/3/2025, 15/5/2025, and 23/6/2025. On 15/5, my lord, may kindly see, my lord. There are 1, 2, 3, 4. Already they have sought for 5 adjournments, my lord. On 15/5/2025, defendants were allowed a last opportunity to conduct cross-examination of PWs with a cost of ₹500. Defendant already had to pay a cost of ₹600. It was also mentioned in that order that payment of cost was condition precedent for proceeding further in the case. My lord, may kindly mark it. My lord, this, my lord, 15/5/2025 is very important, my lord. So the order dated 2/7/2025, which my friend has made this impugned, my lord. This is a consequential to date 15/5/2025, but he has not challenged that order, my lord. He has neither paid the, my lord, the cost which has been directed to be paid while filing the application on 2/7/2025. Continuously, my lord, 6 adjournments, my lord, they have sought for. It was also mentioned in that order that payment of cost was condition precedent for proceeding further in the case. Subsequently, on 23/06/2025, defendants were granted adjournment.
Read the order. Okay, what to do now? I think fastest possible way to finish this case is that I will accord an opportunity, last opportunity, they will produce the witnesses, cross-examine the PW, and then it will be disposed of. But if you insist on objection, then I will stay the order, because I'll have to stay the order.
No, but my lord may kindly appreciate one thing.
It's up to you.
Then my lord may fix
Better
a
way-
short date.
yeah, short
Fix
date.
a short date, my lord. In the meantime, my lord, I will file my response in, my lord, by way of an affidavit, my lord. Then my lord will consider, my lord.
It will,
Till then, my lord.
it
no
will
stay.
procrastinate your case.
My lord?
Yeah, in a hurry, it will procrastinate your case. I can pass an order.
No, but my lord may kindly appreciate this, my lord. This has to be, my lord. There are certain, my lord, several procedural laws is involved, my lord, which has been, and my lord, he has not even, my lord may appreciate one thing, my lord, he has challenged only 2 orders, my lord.
Yes.
But my lord, others, my lord, which he has referring, my lord, he ought to have enclosed that order, my lord. Without recording that order, without
My lord,
enclosing that order, my lord.
Entire order sheet has
That
not
cannot
been
be, my lord.
annexed.
No, my lord.
What is left?
No, my lord.
Entire order sheet has not been annexed.
So my lord
There
may
is no-
fix a date, my lord. There is no stay, my lord. Let a date may be fixed after 7 or 10 days, my lord.
Place your argument. I'll have to stay. I'll have to say, you proceed, you place your objection on all the procedural laws. I'll have to stay. Otherwise, if you place your argument, then there's no point of filing this petition. No
Then-
point in filing this petition.
Then short date may be given, my lord. Fixed date, my lord.
Hmm.
My lord may stay it, my lord. But a short date may be fixed, my lord, so that, my lord, I can submit my objections, my lord.
Okay, stay and then short date.
And my lord may observe endeavor may be made to dispose of this on that
Yes,
day.
yes. Learned Counsel Mr. L.K. Bora
Yes.
is present for the petitioners, and Learned Counsel Mr.
M. Dutta, my lord.
M. Doctor. Your name is not reflected, however.
For respondent number 2.
Is present for respondent number 2. Caveator is not present today.
My lord, I am for the caveat only.
You are for the caveator.
As Das, my lord. He is my associate, my lord.
Okay, okay. The respondent number 2, comma, caveator, full stop. The petitioners are everybody orders dated 4/9/2025 and
2/27 to 2/7/2025
2/7/2025
and 4/9/2025.
and 4/9/4/9 to Pasad DDY in connection with
TS number 3 of 2020.
TS number
3 of 2020. Passed by the Civil Judge Junior
Yes.
Division number 1.
TS number 3 of 2020 passed by the Learned Civil Judge Junior Division
Number 1.
number 1 Golaghat.
Golaghat.
Full stop. It is submitted that the petitioners were not accorded an opportunity to cross-examine the PWs and to adduce defense evidence. Now this case is fixed for argument. Full stop. The petitioners will be highly prejudiced if the petitioners are not allowed to contest their proceeding in its proper perspective. Contest the proceeding in its proper perspective. Full stop. It appears that stay of the proceedings may be granted at least till the next date of listing. Further proceedings of title suit 3 of 2020 is hereby stayed till data deduction. Notice to be issued to respondent number 1.
One, my lord. He can, my lord, family member, he can take Dusty also, my lord.
To routed through Dusty service and returnable on 16th November. November day, 16 October.
My lord, my objection may kindly be recorded.
The learned counsel for the to Mazul Bhadivadi has raised serious objection against the prayer of stay liquidated. The learned counsel for the respondent who has also submitted that he will submit an objection.
Submit objection, my lord, and he may be objection, my lord.
He'll place his objection now.
And my lord, endure may be, my lord, death part, my lord.
Yes. Is this matter for disposal at the stage of this matter liquidated? This matter may be taken up for final disposal on the next date fixed.
What's deeply was?
I too now. It will caveat to discharge agent.
Item 10 for referral to the mediation.
This is not a case for mediation, lordship. Other sides, otherwise, lordship, the case is ready for hearing. 2018 matter.
Will fix it for hearing?
Yes, lordship.
Learned counsel, Mr.
SP for my lord.
SP Somano.
Yes.
SP Somano is present for the petitioner. And learned counsel, Mr. M. Khan.
M. Khan for 1 to
Is
6.
present for respondent number 1 to 6. So both the parties have submitted that there is no element of settlement and the matter may not be referred for mediation. List this matter for hearing after puja vacation.
My lord, any date, lordship. Can it be on 16?
List this matter for hearing on 20 November.
8. Obliged.
Item 11.
May it please your lordship. Your lordship, this case is not fit for mediation, your lordship. We have denied liability in this case.
Learned counsel Miss B. Bothakur is present for the insurer and learned counsel Mr. A. Asarja is present for the respondent number.
Legal heirs of the
Legal heirs
the
of the
claimant.
claimants and learned counsel
And for
Miss
respondent number 4.
A. M. Chaudhary
Yes, Lord.
is present for respondent number 4. Both the parties have submitted that this case is not fit for mediation as there is no element of settlement. So, list this matter for hearing on.
It is not, it cannot be fixed for hearing since in this case, your lordship, respondent number 1 claimant has expired, your lordship. And we
Okay.
have filed
List
substitution
this
petition.
list this matter on the video. 24th October.
Item number 12 for admission.
May I please allow you? Last occasion, your lordship was pleased to condone the delay of 64 days in filing the regular first
My lord,
appeal.
a copy of appeal memo is not served to me. ma'am.
Af-
Copy of.
After admission, I will provide. Lordship may admit the matter.
Learned counsel Mr.
PP Bothakur.
P. Bothakur is present for the appellant and learned counsel Mr. A. K. Gupta is present for the sole respondent.
Respondent number 2, my.
Is present for the respondent number 2.
One already expired, my lord, in the year 2021.
Just now I got this execution case. also.
Exactly, item number 6.
You were there. Somebody else was there.
Yes, my other side is them, they filed the CRPIO. And lordship was pleased to fix the matter on 25th of this month. CRPIO.
My lord, in this case, already the final decree was prepared and my lord, already the execution is going on, but he has now challenged the preliminary decree, my lord.
I'm not now challenging, it is
Earlier he
challenging,
has filed.
where
So
2018,
he
there was a delay, that's why. Before passing of the final decree, I approached this honorable court, immediately after passing the preliminary decree. my lord.
And I have seen the execution proceeding also.
Yes.
I don't know how you will benefit in this case, I do not know, but we'll admit it. Admit or the petition, the appellant is aggrieved by the judgment and order dated 18/7/2017
Yes.
passed by the learned civil judge, senior division in TS number 61/2015. Admit the So we'll have to call for the lower court
Yes,
records.
it is necessary.
Call for a lower court record, trial court records. The respondent number, one respondent.
Two, ma'am. Respondent number two,
Okay,
ma'am.
good. You are for respondent number two.
Two.
Call for the trial court records. Meanwhile, issue notice to the respondent number
One
one.
already expired, ma'am.
Expired. Already name struck out by order dated May 2024. This
Then
one
either-
was struck out. Yes.
Only to the petitioner, appellant as well as the respondent
Mother and
number two.
daughter.
Mother and daughter are the other side. The son filed it. Yes.
Mother and daughter.
Yes. The name of the mother already struck out by this honorable court.
Already the name of respondent number one has been struck off.
Yes,
As the respondent number one has passed away.
passed away in the year 2021.
Good. Extra copies, the learned counsel, for the petition, appellant to furnish copy of the appeal memo to the respondent.
I'll send it, deliver it right now. I'll provide a copy to him. He will accept it. And Lordship, there is a IA also for stay of the proceeding, so 2933 2025.
But you stay, everything is over. A decree is executed. No.
Lordship, whatever they filed the
that's
CRP, they
This
filed
will
the
be very
CRP
funny.
for one thing that, Lordship, their mother expired, they concealed the entire fact before the trial court also, before the executing court also. In fact, before this
Now
honorable
you
court
can-
also.
Come up for, on another day. Now that I know that the decree is in progress. No. List this matter after puja vacation. After puja vacation?
After puja vacation, I
No,
pray for the
not your
adjournment.
item, not your item, their item.
Date
I
to be-
also pray for the adjournment, ma'am, after
Okay.
puja
Date,
vacation.
date to
Yes.
be fixed, madam.
After puja vacation.
Last day, he said that here urgency.
On the 13th.
Learned counsel, Mr.
Siladitto.
Siladitto is present for the petitioner and learned counsel, Mr. R.K. Moore
Yes.
is present for the respondent. This matter after puja vacation.
Obliged.
Item 14.
Well, service is completed in this matter. My lord, respondent number 6 has filed affidavit in opposition on 10th of this month, my lord. My lord, in the affidavit in opposition, there is a specific prayer that that he is not the proprietor of the property, my lord. My lord, so we need instruction from our client, so my lord, matter will be fixed after vacation, my lord.
Okay. Learned counsel, Mr.
Be secure, my lord.
B. Soikia,
Yes, my lord.
has prayed for adjournment. Learned counsel, Mr.
Yeah, Ahmed for.
K. Ahmad is present for respondent number 6. Anybody else?
Government also there, Lordship, 1 and 3 laws.
Learned government advocate, Mr. T.R. Gogoi is present for respondent number 1 and 3.
Lots.
List this matter after puja vacation.
Can it be on 23rd of October, my lord?
Can be. Can be.
Much obliged.
Item 16.
May it please, Lord. That we have silenced, my lord, here the impugn order, my lord, page 33. Regarding custody of minor son, my lord, I am the mother. Here, my lord, marriage took place, my lord, on 4th August
No
2015.
issue notice.
Not, the child was with me. And since 2020, my lord, they are living
Your
separately.
function.
I am the mother, my lord.
Mother.
And then, my lord, they are living separately, my lord, from November 2020. Child is with me. I have admitted her in school, my lord, and examination is going on. Then suddenly, my lord, I filed a maintenance case. Maintenance was granted. He refused to pay. Warrant has been issued. Then, my lord, subsequently filed a case at Dibrugarh. I am from Shivsagar, my lord. Then I approached this honorable court for transferring the case, and this honorable court, my lord, page 31, was pleased to stay the operation of the said proceeding, my lord. Page 31, my lord.
Okay.
Now, my lord, this impugn order has been passed ex parte behind the back of the petitioner.
Proceeding was stayed.
Lordship.
Maybe they did not give a copy of this order.
We have annexed the certificate copy, immediately we have furnished, my lord. That was not recorded in the order also.
Definitely, the court didn't come across the. copy.
Maybe, my lord. And
8/2022.
Lordship.
Means guardianship case number 8/2022.
No, yes, my lord.
Equivalent. Who's agreed by the judgment and guardianship certificate has been issued?
No, no.
Has not been issued. Only an order has been passed.
Order has been passed and my lord, Child Welfare Committee has taken the side, my lord,
Okay. Has taken the child.
in terms of this order.
So what is the point in granting stay?
Child will with me and his examination is going on, my lord.
Hmm.
They will bring, my lord. I have a file, IA, my lord, for stay and annexing the examination schedule, my lord.
No, no,
Case for,
no, you'll approach the other, you'll approach the court there, down. Court
my lord,
below.
page 48, my lord.
Party order was passed.
Lordship.
I'll dispose it off.
Lordship.
Huh? To contest the proceed and the court will proceed.
Lordship.
This order was passed ex parte.
Expertly, my lord.
This court cannot pass all these order with interim orders. We can decide, we can pass an order first.
Otherwise, it will be go back, finally also, my lord, it will go back for fresh trial, because ex parte order will go.
Then why didn't you pass any order for, file any application for vacation of ex parte order before the?
This
court-
my lord, final order, my. So, my lord,
Final order, but
Lord.
can be vacated if passed ex parte. Guardianship certificate is also not issued.
Lordship. Page 49 is the report of police, my lord. Child was forcefully taken. Child was not, he did not want to go.
Means period of limitation.
Lordship.
Then I can.
Lordship.
Hmm.
Within limitation, my lord. Otherwise it will not be listed.
Hmm. Guardians and wards এখন দিবাচোন কিতাপখন।
Oh, nice. Awesome.
No, this is not pass ex parte.
No, page, paragraph 23, Lordship.
Huh?
Paragraph 23, no.
No, this is not ex parte. Written statement has been considered.
Lordship.
Written statement has been considered. This is not
No.
ex parte order.
My lord, we file written statement, then we, my lord, approve this all court for transferring the proceeding from Dibrugarh to Jorhat, my lord. This all court stay. Subsequently, proceeding has been expired. Page 23 and 24. Paragraph, my lord. Page 43.
Issues were also framed.
Findings, my lord, page 23, paragraph 23 and 24. Page 43, my lord.
Okay. Under section 47A only.
Lordship.
Okay, I'll come back and dictate an order. I think I'll send it back. You'll contact bail of rupees 1 lakh with 2 local sureties.
Item 16 can be completed.
Third Learned Counsel, Mr. R. Ali, for the petitioner, naam likhibo nalag, who has filed this, or for the appellant, who has preferred this appeal. This is an appeal, no?
Lordship.
Under section 48. small a-
47.
Oh,
47.
under section 47, small a of the Guardians and Wards Act 1980, oh, 1890, 1890, against the impugned judgment and order dated 31/7/2025, passed by the learned additional district judge Dibrugarh in Miss guardianship case number 8/2022, appointing the respondent as guardian of Miss transfer P, capital P within bracket C, bracket close, capital C, 76/2024, dated 21/11/2024, between the petitioner and the respondent clearly reflects Miss transfer case between the petitioner and her, filed by the petitioner, clearly reflects that the proceeding of Miss guardianship case number 8/2024 was stayed till the returnable date. It is submitted that the stay order was not vacated.
No.
So it is submitted on behalf of the appellant that while the stay order was still in force, comma, the respondent procured an ex parte order in connection with Miss guardianship case number 8/2022. Full stop. The paragraph 23 of the order dated
31/7.
31/7/2025
25.
in Miss Guardianship case number 8/2022 clearly reflects that the proceeding was decided ex parte. Full stop. It is submitted that the applicant was not at all not at all aware that despite the order of stay by this court, the respondent went ahead with the Miss Guardianship case number 8/2022. It is submitted that suddenly on 3/8/2025, the respondent came to Mothrapur PS and handed over the judgment and order dated 31/7/2025 in Miss Guardianship case number 8/2022, whereby and whereunder the minor son of the petty appellant was given in custody of his father, i.e. respondent, the minor son is not at all willing to go with his father. There was no negligence or laches on the part of the appellant in contesting the proceeding. It is submitted that the impugned ex parte judgment and order is liable to be set aside, and the matter may be heard on merits. I have given my thoughtful consideration to the submissions on behalf of the petitioner, who's from the annexure. Three of the petition clearly reflects their order of stay granted till the next date of listing by the order dated 21/11/2024 passed by this court in transfer petition, transfer PC 76/2024. I have also scrutinized the impugned judgment and order. And it is true that the proceeding was, that the case was decided ex parte. It appears that an opportunity may be, this court deems it appropriate, this court deems it appropriate that an opportunity may be accorded to the appellant to contest the proceeding. Thereby, the ex parte order dated 31/7/2024 is hereby set aside and is remanded back to the trial court. The appellant is directed to immediately appear before the trial court and submit her evidence. Written statement has been submitted. And adduce her evidence and contest the proceedings. Disposable. In terms of with above observation, this appeal stands disposed of. So IA2, it will be in order as per order detail.
Item 17.
In view of the order detail. We have called for records.
No, this is motion.
Motion.
Aspect.
May it please your lordship. My lord, let the matter be posted immediately after vacation. So
Okay.
I have requested the same.
Learned Counsel Mr. A. Nazari
My name is Ena.
has paid for adjournment. Learned Counsel Mr. A. Sakkar is present for the respondent. Please this matter immediately after the vacation.
After 16th of October, madam. After 16th of October.
Please this matter after vacation.
Yes. Oblige, your lord.
I can 18 for daily hearings.
On last two occasions, also they are 5 times also.
Petitioner is not represented. Please this matter after
vacation.
puja vacation.
Here, please, your lordship. I'm sorry.
This one.
Yes, 18. I was sitting here only.
Yes. You are sitting.
Yes, lordship. I'm sorry, lordship.
No problem. All right.
My lord, here the petitioner was arrested, lordship, on 9/3/2025.
9/8/2025.
9/3. As on date, 195 days. On last two occasions, lordship was pleased to grant me sufficient time to argue this matter. Lordship may kindly come to the FIR, lordship, page number 16.
Page 16.
Page 16, my lord. My lord, got it?
Page 16 is the FIR.
Yes.
Hmm.
Lordship may kindly peruse the FIR, lordship, and spare me from reading the FIR. I'm not going to read that.
Okay, who is the petitioner?
Petitioner is the lordship, father-in-law of the deceased.
Okay.
And in this case, my lord, charge sheet was submitted on 27/3/2025.
Father-in-law of the deceased, the woman.
My lord,
Father-in-law of the woman who died.
yes.
Oh.
And
Charge sheet was submitted
on 27/3/2025. In as much as
27/8.
27/3.
Okay.
In as much as 12 persons are named in the charge sheet. My lord, may kindly come to page number 53.
Charge sheet is accused.
Yes.
12 persons are accused in the charge
Yes.
sheet. Okay.
Page number 53.
Hmm. How old is your father-in-law?
68 years. All the persons, my lord, who are charge sheeted in this case, either are my son or daughters or their husband or their spouses. All are on bail.
All are on bail.
Yes. And the ground on which bail were granted to them is different, considering that grounds of arrest were not furnished.
Yeah.
I'm not going there, my lord. Page number 53.
Yes, page 53.
Page 53, second paragraph, last paragraph.
Yes.
During the investigation, it is revealed that one so-and-so was first wrongfully restrained by so-and-so and so-and-so, then wrongfully confined in the house of so-and-so, that is the petitioner. Tied him with rope and badly assaulted by the FIR named accused persons, namely so-and-so, so-and-so. Their name of the petitioner is also there, Siddiq Ali. Now, my lord, may kindly come to the next 5th line. It is also revealed from the relevant evidences and from the examination of witnesses that the accused, namely so-and-so, was firstly assaulted, mainly the FIR named accused persons, namely so-and-so, so-and-so, so-and-so.
in the kitchen room of the deceased so and so by blaming her that she was having and so with so and so. Here, Lordship, if we peruse the entire paragraph, so far as the assault on the
I think I have rejected his bail earlier. No, not rejected. Okay. His name is not there.
his name is not there. Apart from that, I'm not going on into the merit of the case. 198 days. All the other, my lord may kindly come to the next page, 54. These are the name of person against whom charge sheet has been submitted. All are on bail. Though they were granted bail on technical. Yes,
We had to grant them bail for some other.
yes,
case.
yes, yes. I'm not on that matter. But
I
offense
think
is
before
serious.
investigation was completed, we have granted bail, no?
My lord, that was because of the reason that grounds of arrest were not furnished to them. So I'm not taking that ground. So
Even
my humble
completion
submission
of
is that
investigation.
almost 200 days charge sheet submitted, the prime accused are on bail. I am 68 years old. Lordship may kindly allow this petition with any condition. That is
Yes,
my
yes.
limited prayer, my lord.
Yes, lock up.
Lordship. As per the record, Lordship, there are some witnesses statements have been recorded, Lordship. 164 statement, 183 statement has also been recorded, wherein they have specifically
Read, I
indicated.
have read those statements. I think I have
Yes,
granted bail to some others.
Lordship has gone through
On
even
grounds of
all those
arrest.
are on ground of arrest. But Lordship here, Lordship, now this case is Lordship not on, he is not paying for ground of arrest, Lordship. So Lordship has to go look into the merit, no? What is their material against him, Lordship. So Lordship, 183 statements also, he has some, the eyewitnesses has specifically admitted, Lordship, implicated him, Lordship, that he was there also. Even his statement is also there, wherein he himself has admitted, Lordship, that yes, I also assaulted him. So Lordship, if you Lordship kindly go through the statement of the 183 statements, statement of the witnesses, eyewitnesses, everything, he has been implicated, Lordship. So Lordship, at this stage, Lordship, merely on the ground that some accused have been released on bail, Lordship, that too in another ground, Lordship. And Lordship, probably this is not a fit case for granting bail, Lordship. Wherein Lordship, some 103 is involved, Lordship. Madam, may I submit just one line? No doubt, Lordship, the offense is very serious. I am not on that. The person, there were some allegations of having some extra so and so.
Okay.
But
that you see, life of a person
Yes,
has
yes,
been
I'm not-
eliminated.
Yes.
Everybody has a right to
Yes.
live,
But
right
Lordship,
to life, I mean.
that offenses were committed by my children, my lord. I am 68 years old. They are on bail. And the unfortunate part of my side is that that incident took place at my house. I was there. That is my house. Obviously, I would be there. And so far as the assault on the daughter-in-law is concerned, admittedly, my lord, it is not there. Even video footages are there. I have not assaulted. So considering that aspect, considering my age and considering the
You
fact
don't
that.
need to assault actually. Being the Murabi of the house, you're the
Yes,
Murabi
yes,
of
my
the
lord,
house.
I can
You
understand.
also have stopped that girl from being killed.
That is there, my lord. I mean, Lordship, it's a case, my lord, where I have very less scope to submit, my lord. But considering the age and considering the fact that other persons are on bail, and I am ready to face the trial with any condition, my lord. Not the all, keeping me in custody, Lordship. Not all the accused persons are bail on bail, Lordship. Those who were arrested. Who were arrested, Lordship. There are some.
Because those days we had this judgment, so maybe during investigation also bail was granted.
Those bail were granted, Lordship, referring Vihan Kumar. I'm not on that. Because Lordship, not event charge not yet framed, Lordship. So at this stage, Lordship, it is not a fit case, Lordship. And some persons are yet to be arrested.
No, I don't think so.
Yes, madam.
Charge sheet has been submitted.
Charge sheet has been submitted. Charge sheet has been submitted.
But they are not appearing.
They are not appearing.
Summons has been issued.
Summons has been issued. They are yet to be appeared also. 5%. They are not
are
yet
yet
appeared also.
Absconding.
That's it. So in that way, my lord, it will take some more time. My lord, kindly allow me with any condition. I will not fail any date. And already 200 days.
I will go through the CD.
Yes.
If he has a role to play, I won't grant bail. And
I'm leaving
I
it up to
already
your
take my
lordship.
team, Lordship. Lordship, may kindly pay this, Lordship.
There are two eyewitnesses, my lord, may kindly pay this. One is there at 139 and another is at 140.
if 34 or 149,
And so far as the assault part is concerned, two persons were assaulted and the allegation of assault against the present petitioner is against the other person. He assaulted that other person, not the lady who died. Rest I'm leaving it up to your lordship. Lordship may kindly pay.
if that is true, then I will grant bail. If he has assaulted the other person who has survived,
Yes,
then maybe
yes, lordship.
bail can be
Even,
granted.
my lord, two FIRs were there, lordship. Subsequently, both the FIRs were amalgamated. One was by the other person who was assaulted, Salimud.
I'll check
Yes, my
the.
And that
transport
age
records.
aspect may also be considered. The
No,
petitioner.
Age cannot go.
I'm leaving it up to you.
68 is no age nowadays. Our span has increased. India.
Now it is 70, 75
longevity
years.
has become 69, I think, now. Average longevity.
Who's uh,
69 for men, maybe 71 or 72 for women.
Still my lord. Highly applies.
এইটো মই দি দিম দিয়ে দি দিম ডিসপোজ দেখাই দিম
Item 19. Sorry.
Lordship, I would like to mention item number 33, your lordship. Lordship,
item number 33
yes, your lordship. Actually, lordship, I am traveling from Delhi to attend this matter. My only request is it be taken today, no more. Like at 3 o'clock or 3:30, whenever your lordship pleases. Lordship, may just
next
take-
one I'll take up as the next item.
please, your lordship. Oblige, your lordship.
May I please, my lord? My lord, in this case, trial court records are received. My lord, as per office notated 16:09, service is complete, my lord.
Am I, as no one is present today on as for respondent number 2, no? Two. Lordship, may kindly appoint amicus.
Yes, I'll appoint an amicus. Learned counsel Mr. A.K. Gupta is present for the petitioner. Office note dated
16:09,
16/9/2025 reflects that indicates that respondent number 2 has received notice office to appoint a legal aid counsel or amicus
Amicus.
or office to appoint an amicus registry to appoint an amicus curiae to represent the respondent number 2. List the matter after vacation.
if possible before vacation, because my lord, he is in jail for more than 1 year, my lord. Trial is going on.
Okay, list this matter on কেতিয়া দি দিও এতিয়া আগতে দি দিও 2050.
Oblige.
Updated item 33 for orders.
May please, your lord.
Yes,
Lordship, this is for the condonation of delay, your lordship, in this matter. Lordship, the judgment was passed on, an ex parte judgment was passed against the appellant, against me.
what about the other side? Office note dated 26/8/2025. Notice have been issued to respondent number 1 and 2 by registered post and by usual process and dusty service.
Lordship, they have appeared.
Notice have entered appearance
Yes, yes,
on
Lord.
behalf of respondent number 1 and 2
Yes, your
by filing wakalatnama, but they are not present today.
yes, your lordship.
Hmm.
Lordship, the exigency,
I'll just check the number of days. What is the delay? Length
Lordship,
of delay?
lordship, here, you have been. It is around 90 days, your lordship. I can explain the delay also, your lordship.
No, I can condone the delay, but the other side has to be heard.
Your lordship, the exigency is that they have filed an execution in this matter. So unless and until I have a stay in this matter, that matter is proceeding, your lordship.
Do you have an, oh, no stay. But the other side has to be heard because this is 90 days.
Yes, I concede to that, your lordship, but
Had it been for 10 days, 15 days, I would have easily passed an ex parte order controlling the delay. But 90 days, I have to hear the other side.
lordship,
Who is the advocate on the other side? Have they filed wakalatnama? Notices have been served, but advocates have entered appearance on behalf of respondent number 1 and 2 by filing wakalatnama. Wakalatnamas have also been filed. Have the names been reflected? Names of, oh, okay, just for NN Jha. If you know them, you can contact them. I'll hear it after some time.
please, your lordship, but the only request is that this is the actual delay is lesser than this as per the.
Your lordship, 33 by senior is another court. May I call him, please?
Yes, we'll wait for some time.
Please, your lordship.
Item 20.
Wait, please, your lordship.
Now, please, your lordship. Your lordship, Mr. SCKL is on legs in court number 3, your lordship. The matter may be taken up next week, any day, your lordship. We filed our written objection also, your lordship.
Your lordship, my simple prayer is that in this case, my only ground is long incarceration. The last witness was examined on 23/6/25 and was examined on July 2024. And since then, no witnesses has been examined. The accused is behind the bar since 3 years, 4 months. He's already behind the bars for 3 years, 4 months. And for the last one year, 2 months,
case?
Yes, your lordship.
no witnesses has been examined. No witness has turned up in the court. In fact,
You're behind bars for how many years?
3 years, 4 months. Charge sheet was filed on
This is
16th,
the first application or?
second application.
The first application was rejected.
Was
your lordship.
rejected.
By me?
Yes. It was.
Okay, let it be listed next week.
Yes, your lordship.
Next week. Learned counsel, Miss?
P. Upadhyay, your lordship. On
P.
behalf.
Upadhyay on behalf of Learned Standing
Mr.
Counsel.
Yes, your lordship.
Mr. SCKL for NCB.
Yes, your lordship.
Has paid for adjournment. This matter next week, 24th September.
Obliged, your
On,
lordship.
on 24th.
24th September.
Yes.
Item 21.
Here in this case, we have not received a CD, lordship. He's on interim.
Lordship, pursuant to the interim order, we have appeared and got our statement accordingly.
You have not received a CD.
CD, lordship.
CD has called for is not received. We should reminder list the matter because of Bishop Dijo.
After vacation also.
Interim order shall remain in force till the next date of listing.
It's okay.
May please, your lordship. The facts of the case are like this, my lord. My lord, the petitioner, my lord, entered into an agreement for sale with the defendant, my lord, Niranjan Burman, for purchase of 1 bigha 2 katha 10 lesas of land.
Okay.
Now, the respondent, he did not go ahead with the agreement for sale. Thereafter, my lord, what he did, he filed a suit, title suit. That is title suit number 1 of 2023 against the present petitioner for eviction. He says that they were permissive possessor, they were only allowed to cultivate. Now they are not going, so he filed a suit saying that they should be evicted. So in that case, in that suit, title suit number 1 of 2023, the petitioner received summons and he appeared and he contested by filing written statement. Thereafter, my lord, the petitioner, he filed a separate suit. Because our grievance is that, my lord, we had an agreement for sale, that is the Bainanama. On that basis, we had entered possession. So, in the suit filed by the respondent, we filed WS saying that on the basis of an agreement for sale, we were in possession. And side by side, we also filed a separate suit saying that the agreement should be entertained. That is the suit for specific performance. Now, what he did was that in our suit, he was issued summons He appeared and filed a petition under section 10 for staying, and the learned court below, by the impugn order, stayed our suit. That is our grievance. Yes,
So we'll issue notice then.
yes, notice may be issued.
Learned Counsel Mr. S. Das is present for the petitioners. Issue notice to respondent, respondents reasonable within 4 weeks. List accordingly.
But can this be added that my lord the suit, that is TS number 1, in which we are defendant, my lord, shall be, my lord, subject to the outcome of the present CRP, my lord.
No,
Otherwise, my lord, if
Without
that
not-
suit is
no.
decreed, then my lord, our suit
no,
will
no,
be
then we are passing off from
no,
final
no,
order.
that's subject to outcome, my lord, no interim.
No, no.
My lord. Highly opposed.
May I please, Your Lordship, this second appeal, my lord, though it is a concurrent, but substantial question of law involved, it is page 6, my lord, Your Lordship. We have challenged this sale deed, but page 6. That sale deed that was executed in favor of the defendant who are the minor, that is barred under section 11 of the Contract Act. It is one of the question of law we have framed here. Page 6.
We'll have to go to the decision of the appellate court at least.
My.
Before framing the substantial question of law,
My.
at least I'll have to read the decision of the appellate court.
Your Lordship, my. That page 38, that is the findings of the appellate court. From which, my lord, I have formulated that substantial question of law.
Page 38.
38. My lord, it starts from the 37 last, 10.1.19. Here it reflects that that sale it was executed in favor of the defendants, number 2 and 3, who are minor at that point of time. Can it be? And it is my late father, it is shown that my late father executed that sale deed in favor of the defendant number 1 and 2. We are possessing, it is shown that I have challenged that sale deed, that is a forge, because my late father executed the sale deed in favor of defendant number 2 and 3, but the defendant number 2 and 3 were minor. That reflects from exhibit 5. And that reflects in the findings of the appellate court in page 38 also. So it cannot be under section 11 of the Contract Act. Both should- Mine. Secondly, my late father was, my lord, literate person, but in the sale deed, it is thumb impression. An expert was examined. Expert says there's some discrepancies there also. That is also the findings. On these 2 points, when it may be admitted, notice may be issued.
No, contract.
My lord, this
Indian Contract Act.
Indian Contract Act, page, that is section 11. Every person is competent to contract who is of majority.
But you have not taken the plea that it was a sale deed, no? That the Wendy, they were minor, you have not taken the plea anywhere.
I have exhibited exhibit 5 that they're mine. Exhibit 5 is
No, but though that plea was not taken anywhere. Only the forgery plea was
forgery,
taken.
forgery.
I'll take that, that cannot be a substantial question of law. It has been decided
My lord,
on facts.
yes, that is on, if I say the fraud and forgery,
But that plea was not taken, that they were minors. No way it was taken. You cannot introduce new plea in the appeal.
no, it is not a facts, my lord, they admittedly, the different number 2 and 3 minor. That is reflects in the judgment also. So if it is there a question of law, then whether it can be transferred or not. And that deed, sell it is a correct or not.
Where is the sale deed?
Send it, it is not, it is record matter, record matter.
I'll have to check the record.
No, it is the first time matter for admission.
There's not a whisper anywhere that the defendants are, or that the vendees are minors.
No, defendants are minors. For that, my lord, I have exhibited exhibit 5.
Defendants are minors,
Defendants are minors.
not the same vendees.
No, not the vendor. Vendor, my late father. So if if there is contract, the parties should be measured, both parties. I cannot sell a land to the minor. That is the section 11 of the contract act.
But it is not discussed in the judgment.
That is one of the question. Discussed, but not elaborate. That if page 37. Page 38. One guardianship application was filed, and in that guardianship certificate, where it is stated that minor. Because of that, my lord, this guardianship certificate was applied, but that guardianship certificate was dismissed.
Have you annexed the plaint and the?
Yes, plaint is there.
Plaint and the
Plaint
WS?
is annexed.
You are a defendant.
I'm the plaintiff.
Plaintiff.
It is actually dispute between the two fathers, two brothers, and
Where is the plaint?
mine. It is at page 46. In page 48, it is, my lord, stated. Regarding minors, I have pleaded this.
Where are the issues framed?
Minor issues. issues in page 12, it reflects. In plain my lord, place 48, where I claim,
Where?
page 48 in plain.
Where in page 48?
Regarding forgery of thumb impression, my lord, that is the findings at page 37.
It is there. Forgery is there, I'm not denying, but there's nothing about the defendants being minors.
Page, I have read it, and that is at page 38 is the findings, my lord.
They are represented by the father defendant number 1.
No, they are not represented.
No, in the plaint it is written that defendants minor, Badruddin,
Yes,
all represented by the defendant number 1.
indeed, my lord, that should be. Indeed, there is no any representation by.
Where is the deed?
That is my lord on record, my lord.
But it's not there in the judgment nowhere. And you have not mentioned in the plaint also.
In plain, I have stated,
No,
my lord, page 40A,
page 48 where?
page
I have read
40,
page 48.
page 48, I've stated that a guardianship certificate was.
No, no, that you have not specifically stated that cannot become a substantial question of law. No issue was framed.
Issue was not framed. That is that is also my lord perversity. That is also,
Perversity, but here page 48, nothing is stated that the defendants are minors.
Yes. That is.
But we don't have the deed also. If we have the deed, then it's okay.
No, I have.
If the defendants are minors and if they are represented by a by their father, then
I have no case.
yes.
Then I will have no case. That deed my
But you
certificate.
have not stated in the plaint in that manner.
Yeah, it is categorically stated, my lord. the defendant number 2 and 3 was the minor. Because of that, defendant number 1 filed a guardianship certificate before the district judge to sell this land to me. That is the guarantee.
But you have not stated that the deed is illegal because the defendants are minors not represented by the father.
I have the certificate copy of that sale deed also.
No, sale deed. You have the certified copy of the sale deed,
Photocopy I have, but
but it's not mentioned in this plaint. When you have not agitated, then how can I frame a substantial question of law? Issue has also not been framed.
issue not framed because
Then even in title appeal also, it was not raised. Additional issue not been framed.
No, no,
Title
issue was
appeal
not-
also, it was not raised. No issue was framed in title appeal and remanded back for
Oh, that is correct. That
to
it
decide on
cannot
the
be unless the issue is framed and it cannot be remanded back on this point. Now, question is that paragraph 1 I have stated. Hmm. Your lordship may frame other substantial question of law also involved here.
I cannot find any reason to frame other substantive question of law.
May I
I'm
frame
agree
an-
with the decision.
No, yes, the decision also is regarding 111 because there is a fiduciary relationship between the vendor and vendee. So 111, under 111, burden lies upon the defendants, the vendee to prove, defendant vendee to prove that there was a in 111 of the Evidence Act.
But it has been correctly decided that burden lies on the plaintiff to
No, that
prove
is
his
that,
case.
that is an exception, my lord, to that. If there is a fiduciary relationship, it cannot be. It is the burden lies upon the
If there is a fiduciary relationship.
yes, but two brother. In paragraph 12, the Supreme Court says, when we plead the fraud and misrepresentations, that's section 11. Because
Paragraph 12.
paragraph 12, because my late father was at that point of ill.
Can you read the entire paragraph?
12. As has been pointed out by the High Court, the First Appellate Court totally ignored the relevant materials and recorded a completely erroneous finding that there was no material regarding age of the executed when the document in question itself indicated the age. The court was dealing with a case where an old aging illiterate person was stated to be executed and no witnesses was examined to prove the execution of the deed for putting of the thumb impression. It has been rightly noticed by the High Court that the courts below have wrongly placed the onus to prove execution of deed by the Dashok Kumar on the plaintiff. These are the challenge by the plaintiff to validity of the deed. The onus to prove the validity of deed of the settlement was on defendant number 1. When fraud, misrepresentation, or undue influence is alleged by the party in a suit, normally the burden is on him to prove the fraud, undue influence, or misrepresentation. But when a person is in a fiduciary relationship with another and the latter is in position of active confidence, the burden of proving the absence of fraud, misapprehension, or undue influence is upon the person in the dominating position, and he has to prove that there is a fair play in the transaction and that the apparent is that real, in the other words, that the transaction is genuine and bona fide.
Just a moment.
My lord.
Evidence এখন আছে নেকি?
May I point one thing again with page 41A? Your lordship stated that, my lord, I have not stated about the minor. Page 48, my lord, for me. Here it is, but question comes that deed number 2342, which is by under challenge, schedule 1 in the name of the minors.
Minus,
Minors.
but you have not challenged it, that it is not a.
No, it is because of that, my lord, the defendant number 1 submitted a application of guardianship. And that reflects from the cell deed also that it is on behalf of the defendant number 2 and 3, it is not executed. Defendant number 2 and 3 minor, they have executed. On behalf of them, it was executed. That is. There is no dispute that they are not minors. When they differ in their written statement, they have not disputed that they were minor. Defendant number 1 has not disputed. If it is not disputed.
No, but you cannot introduce this suddenly, you cannot introduce a dispute.
Because it's a question. Section 11 of the contract. Because of that. Not suddenly, we raise the question, defendant not disputed. So it is admitted that is minor. And because they were minor, the
But I
defendant.
cannot grant stay. I'll take.
No,
this
I am
up.
not spraying for any stay, mine. I cannot.
Only one question of law, I'll take.
Minor.
Frame.
Minor. Because the land is under my possession, why I can pay for stay?
But you see, when, actually, I don't know whether I can frame such a question of law. Because when you come for appeal, you have come for appeal, then you have not disputed that this issue was not taken up. So then the first appellate court will frame the issue and send it back for remand the case.
That is correct, but
And
this issue can
this
be.
is what is the.
My lord, it
process.
could have been, but this is, since it is a question of law, your lordships can, my lord, it can be in affidavit.
No, no.
Recited.
No, but there are so many judgments. You have shown me judgments. I also can give show so many judgments that new issues cannot be brought up in an appeal
Actually, particularly this issue was not.
and cannot be decided also. You have to remand back. New issues cannot be.
That also can be by this honorable court. After admitting this, your lordships can also. They reframe issue on this point and decide. This honorable court also can. After framing this question of law.
So this is at the stage of motion, isn't it?
Motion. Admission.
Let me ponder over it. I'll fix it for next week.
Mine.
Let me ponder over it.
Mine.
I'll keep it with me. I'll read.
Mine.
I'll read this judgment also.
Mine. That is in respect of 111. That is.
Hard Learned Counsel, Mr.
And Hawk.
And Hawk for the appellants. List this matter on next week or TDS one. Motion on 25th September.
Obvious.
Item number 33, upgraded.
Please, your lordship.
Yes.
Lordship, this was a.
94 days. Yeah,
Nine-
any
90
objection
days.
from your side?
Your Honor,
Yes.
your lordships, my objection is regarding the, petitions, please perused. The para 3 of the applications. The delivery was made on 19/12/24. And thereafter it is filed on, Your Honor, in the month of February. But February 2025, 28 February 2025. So from 19/12/2024 to February, there is no explanation. And Your Honor, this is para 4 of the application. What is written, Your Honor? Until now, this will be cure. How can we allow it? Para 4. Yeah, read, Your Honor. Para 4 is important.
Yes,
Limitation application, Your Honor.
yes, limitation application.
Para 4.
Hmm.
What is your?
1503. 1503? Yes, para 4, yes.
Para 4, Your Lordships. For the facts and reasons stated above, it will be expedient in the interest of justice that this honorable court may graciously please to allow the present ST applications. and stay the effect and operation of the impugn order judgment that is so and so, so and so. So this is the your honor applications. Under these circumstances, whether the application can be allowed.
Lordship, but the prayer is not affected.
It must be correct. Application should be correct, your honor.
Application has to be correct.
Cut and paste application, your honor.
Lordship. But the condonation prayer is tied, your lordship. That is unaffected, your lordship.
Even your honor, there is no clarity on the, your honor, please read the prayers. Condone the delay of 90 days in filing the regular first appeal against the impugn judgment and order and judgment. There is no degree, your honor. In TS number so and so, there is no date of judgment, your honor. How can this honorable court ascertains for which judgment, from which dates, and how it can be counted, your honor? Even the prayer is not proper, your honor. So it has to be, your honor, in order.
Lordship, the details of TS 443 are already been mentioned prior to that, your lordship. The very first paragraph, the details have been already mentioned.
Okay, then let us allow it. That that paragraph 4 is really very absurd. Paragraph 4.
Your honor, not only that, but there is no explanation even from 1912-24 till 28 February 20.
No explanation.
There is no
also.
explanation to this.
Lordship, we had, Lordship may just have a look at our conduct from the very initiation when we got to know about this matter. We had filed a 9-7 which was rejected. After that, we had applied twice for the certified copies. And your lordship, because on the first, during the first part, we did not get the exhibits. That is why we had to apply for it again. And after that, your lordship, we are counsels based in Delhi. So we had issues coordinating, and that is why the delay has happened, your lordship.
This is not, this very explanation is not here, your
See,
Lordship,
you can file an additional affidavit, I think.
Lordship, I'll file an additional affidavit in that case, your lordship.
Yes. All right.
Please, your
Because the prayer is very absurd.
Please, your lordship, I'll.
Learned counsel, Mr.
Shaunak Datta.
As doctor is present for the applicant, learned counsel, Mr. N.N. Jha is present for respondent number 1 and 2. List this matter after push application.
Your honor.
Please, your lordship.
You want a date?
Yes, your lordship.
Date is a detail. Orders of the Senate, 24th October.
Please, your lordship.
Much a pleasure.
My lord, item 23 and 24, my lord. This matter may be taken after vacation, my lord. This is 34 hearing, I think, my lord.
As agreed by both the sides, list this matter after vacation, puja vacation.
Yes.
23 or 24.
Oblige me.
24 also, Lordship.
Yeah, please, Rashid, in terms of the last order, you have submitted the amended cost item. And in
Yes,
this
submitted.
amended cost item.
Okay.
And here the trial court record has to be called.
It was not called earlier, trial court record.
It was called earlier, but what happened, Lord, it was withdrawn by the earlier council, therefore we filed an I for restoration. So when it was withdrawn, the records have been returned back.
Questions of law were framed.
That's right. It was framed.
All right. Learned Counsel, Miss
V. Rai. On
V.
behalf
Rai
of Mr.
is
SP.
present on behalf of Learned Counsel.
Mr. SP. Roy.
Mr. SP
Roy.
Roy. Learned Counsel, Mr.
T Sheikh, my lord. T Sheikh.
T. Sheikh is present for the respondent.
My lord.
Call amended cause title has been filed.
Has been.
Call for the trial court records. List the matter after preservation.
My lord.
Obliged.
Item 29.
May please, this is a cross objection. So it may calibrated, I will have the copy of the notice.
Cross objection.
Yes, Lordship. Because
It may not be admitted right now, Lordship. We will file our objection to that and notice, I think, to the other parties. You have received copy?
Yeah.
We haven't received the copy as yet.
We
So
have the
notice,
copy.
today notice may be.
Okay. Appellant to take steps to issue notice. This is not in the admission column also.
yes.
It is
No,
in
no,
the
it
orders
is
column.
because notice, they have to give notice first.
Appellant to take steps to, objector. Who is the appellant here?
The appellant, cross objection is filed by them. I am the appellant, Lordship, in the appeal.
50% is also not awarded. 50% is not released, Lordship.
Respondent.
Already that order is there.
Respondent, objector, stroke objector is present. Notice has to be issued to the appellants. A to Harry, cross objection number 8 of 2000 Harry 24. 24 लिखा है
8 of 2020.
8 of 2024.
25 years.
Yeah, 24 लिखा था.
25 मैं चाहिए था कोई कोई से.
কিন্তু নামটো AR আগৰৱালাই আছে.
Cause list of 25 likha hai, sir, 8 of 25.
25 लिखा আছে. There is also there is also a misleading error.
That is why we are filing objection, Your Honor. That's why I'm submitting that we will file objection because there is a delay, huge delay. They have not filed any condonation petition. And that is in 24 they filed, but it was numbered in 25.
Issue notice to the respondents returnable within 4 weeks.
Yes, Lordship.
May please.
Lordship, copy of appeal memo is also not received.
No,
by me.
they have already received. That's why they have filed the cross objection. He is making out a.
No,
different
Lordship,
case.
not yet received.
It was, Lordship, the case was already fixed for final hearing in 2018,
Lordship.
7 2018. LCR received fixed for final hearing.
Because I.
Now in. Let
You
you finish.
are newly appointed.
No. He appeared that time in itself, Lordship.
I have appeared, Lordship, I have held this for release of the 50%, but that is not released yet, Lordship.
Order is there, Lordship, in that it will be heard with the final MSc appeal. Already
You
that
wish
order
to-
is.
Will
I am appearing on behalf of P. Mohanta in the MAC appeal, Lordship. Lordship, we haven't been able to contact the respondent, Lordship. So we seek your permission to retire from the matter and in the.
you file an application. You file
Yes,
an
yes.
application. That will be
Because
better.
Rule 60 of High Court rules, Lordship, they have to inform the party.
Yes.
That is
But
We'll have to inform the party and file an application also.
highly obliged, Lordship.
Item 30.
May I please, Your Lordship? Lordship, I'm appearing for respondent number 1 and 2. We have filed our Kokala number recently.
The appeal was admitted on 28 to 2025, Your Lordship.
Mm.
TCR has not been called for. So my prayer is that
Call.
for TCR.
Learned Counsel, Mr. S. Islam is present for the
Appellant.
appellant. Learned Counsel, Mr.
P. Daimari.
P. Doimari is present for respondent number 1 and 2. Trial court records, as well as original appellate court records and original trial court records to be called for. And anything else?
Nothing.
No,
Regard to respondent number 4, Your Lordship, I guess, notice.
Okay, notice. Okay,
Other respondents.
the service report and respondent number 4 is awaited. 1, 2, 3, 4, everybody has accepted notice.
For Your Lordship, might.
Service
The
report
counsel
and
can-
respondent number 4 is awaited. Do you want to take fresh steps?
For
Four is awaited.
District collector, state council may appear, Your Lordship, because the DC deputy commissioner.
No service report has been received in respect of respondent number 4.
Respondent 4 is district collector. State council may appear.
Yes, can appear. They have to be informed.
There.
You have to serve notice. Mm. Service report and respondent number 4 is awaited. List the matter after preservation.
Oblige, Your Lordship. Oblige.
Yes,
This is a condonation application.
Your Lordship, due to some personal difficulties, Mr. S. Das will not be able to appear for the matter today. If it pleases Your Lordship, may the matter be.
Lordship, I have made a mention for listing of this matter, Lordship. I have seen him in some other courts, Lordship. And they have filed already objection, and this is a matter, Lordship, where my suit was rejected, being barred by res judicata. In fact, Lordship, the earlier suit was filed by the defendants praying for right title, interest and partition, and I have filed my suit, Lordship, against right title, interest and recovery. Both the causes of actions are different, Lordship. So earlier I tried to file a CRP, Lordship. Thereafter, Lordship, the filing section has not accepted this matter. Then as my suit was not maintainable, barred by res judicata, it was held by the impugned order. So I have filed.
In whatever matter he is absent, we will have to
Lordship.
hear him is 240 days.
Lordship,
Condemnation
he
is
has filed
240 days.
already
What
his
you have
objection.
stated that he is not in the court and you have stated that he is in the court.
Yes, he is in the court.
Your Lordship,
Five-
this
five.
is what I was being instructed. Some
Just now also I have seen him in outside, Lordship, Mr. S. Das. Outside the court.
like any date next week would be.
Next week, courts will not give me. Lordship, if possible on Tuesday, Lordship.
But it's a motion day,
Lordship, so order matters, Lordship.
order matters, but motion. Okay,
There,
all right.
Lordship.
Learned Counsel, Mr. Yes,
S. Chaudhary,
S. Chaudhary, on behalf of Learned
Yes, Das.
Counsel, Mr.
S. Das.
S. Das. S. Das, Rosie Das.
Yes, Lordship.
Now he has submitted it, just now he has submitted his argument and left. Let's pray for adjournment. Learned Counsel, Ms. R. Chaudhary is present
If
for
he is
the.
on leg, then we can wait for him if he is on leg.
Sure, Lordship, this is.
I don't think so.
Lordship. So better Lordship may be fixed on Tuesday, Lordship.
Would it be, Lordship, if, would it be possible after 23rd?
Not Lordship,
after Tuesday.
26th last date, Lordship. Then Monday, Lordship. The Monday, Lordship.
24, 25. Is fixing according to the roster. How many cases are fixed? Ms. Ashok is present for the appellant. List this matter on 24th.
Hello, bless.
Whatever delay combination application has been filed by the petitioner side. Here I am appearing for the respondent number 1. For respondent number 2, the service is still awaited, but there is no point of issuing notice to respondent number 2 because respondent number 2 had passed away in the same accident. And his claim, in the claim petition, his proceeding was drawn expertly and none represented him, Lordship. And respondent number 2 was the driver of the vehicle.
Respondent number 2 was the owner of the vehicle, Your
Owner of
Lordship.
the
He
vehicle.
was not the driver. There were 2 vehicles involved, Your Lordship. The drivers of both the vehicles expired in the accident. Now we have implemented the claimant and the driver of the other vehicle. Because in this
The
case,
person who died.
because in this case, Your Lordship, apart from the claim petition, everywhere the other vehicle has been impleted. And if the owner has died, your lordship, we may be allowed to file substitution petition to implement the legal heirs at this stage.
That should have been done in the claim itself. Now it's already a delay because if your lordship arises, the,
No, condemnation, they can't help it, they have to file this.
so I'm not objecting it. Your lordship may condone the delay.
Wait for some time.
The difficulty is that lordship, they filed the appeal in July 2024. And for the last 1 year, lordship, they did not rectify the objection. And in April 2025, they rectified the objection, lordship. Just to delay to make payment in respect of the claimant. And now again, they will file a substituted application, which should have been filed before the MSCT. I do not have any objection. Your lordship may condone the delay. There is no point of issuing notice to him. Because they do not know who are the legal heirs of that particular person. They are not in fact aware. Because that particular thing, they has to collect it from the trial court.
Your lordship, at this stage, if the delay can be condoned, we'll obtain the information about the legal heirs, will file an amended cause title and a substitution petition to implement them. And in the main appeal, we'll take steps upon the legal heirs, your lordship. And then your
Yes.
lordship can decide if it is admissible or not.
Owner, that person is the owner.
Yes, your
The
lordship.
deceased
Owner.
is the owner.
Yes, your lordship, we had to make him the party because in the trial court also he was a made up party in the LC, in the lower court records. But now since we have to proceed, now we'll file the substitution petition, implement the legal heirs and move ahead. your
You are the
lordship.
insurer.
Yes, sir.
You are for the
I am for the claimant.
claimant.
Yes.
He has no objection, he is the main party.
Yes.
So then we will dispose it off. But you see, we'll have to strike out his name then.
Your lordship.
Yes, because he's not a necessary party. Firstly, and this will only delay the matter, lordship.
Lordship, he cannot be struck off at this stage because the main ground of our appeal is
Okay,
that
then you,
there was negligence on the
okay.
part of that vehicle.
Okay, fast, act fast then.
Yes,
You
your
file a petition to implement the legal heirs.
Yes, your lordship.
You act fast. Can't help it.
Lordship.
They won't allow us to, they won't allow the name to be struck off. They won't agree, not allow, agree the name to be
Lordship.
struck off.
Lordship may condone the delay.
No, without the party, with the.
Because here I am the affected party.
Huh?
Here I am the affected party, so
The party's name is still existed, but they not legally valid because you see, his successors have to be implemented.
lordship.
Legal heirs have to be implemented. So either I have to struck off.
I understand, but on the next day they will submit before this honorable court that we could not find out who are the legal heirs. We need some more time.
These are just assumptions. We need to be given.
That is not assumption. That assumption will come true on the very next day.
Your lordship, such submissions should not be made at
Because
this
this
way.
claim petition, this appeal was filed to July 2024. They did not rectify it. What prevented them from rectify the objections? And they rectified it in the month of April this year. And the reason is just to prolong the matter, lordship, not to make
Then
payment,
Strike off the respondent number, deceased respondent. If
lordship.
they are not filing the legal heirs, we'll strike off their name.
Your lordship may make that observation, lordship.
No. We'll strike off. Any court will strike off if the delay.
Otherwise,
stress-
lordship, it will be difficult for me
it will be
because
Procrastinated and a speaking order will be passed, but now today I'll allow some time. You see, it has started from 8/4/2025, so let us give them 1 more month. Learned Counsel Miss
A. Biani.
A.
Biani.
Biani is present for the insurer and Learned Counsel Mr. P. Borana.
Arbora.
Arbora is present for the payment. The Learned Counsel for the insurer has submitted that they will file a petition to implement the legal heirs of the deceased respondent number 2.
Lordship.
List the matter after the puja vacation.
Lordship, may I kindly pray for a
Date,
date?
yes, sir.
And may I humbly pray, lordship, the appeal is though yet to be admitted. Let them furnish a copy of the memo of the appeal, lordship. I'll go through it.
The delay is condoned.
No,
the
no,
appeal is-
that is not, it's a technical difficulty. I am not claiming that I'll make submissions on the main appeal, but it will help me, lordship. they can obviously at least furnish that.
Shiva, in the claim petition also which they filed, the claimants filed, they have made the deceased owner a party. So as per the norms, as per the legal procedure, whoever are the parties in the claim petition are to be made parties in the memo of appeal. That is the only reason we have implemented them as parties. So that when the matter comes before the court, we can make a submissions to impede. Without the liberty of the court, we cannot file substitution petition because first we have to impede the parties in the claim petition. So Lordship, when they are
Alright,
at
alright,
fault
okay.
then for impleading a
Okay,
dead
next date,
person.
we'll fix a date.
Lordship.
Fix date. Date and time.
Lordship. Obliged.
Much obligation, Lordship.
Item 34. Yes, Dr. Chobi is legal. Huh?
May I please, your Lordship. Lordship, kindly peruse the office note dated 16/9/25, my lord. Service is complete on respondent number 124, my lord.
Any more respondents?
No, my lord. They have not appeared, my lord.
Okay, learned counsel, Miss
L. Sharma.
El Sarma is present for the appellant. Office note dated 16/9/2025 reflects that notices have been served to respondent number
124 and 5 refused, my lord. So, service complete on respondent 125, my
1,
lord.
2,
5.
3, 4, and 5.
Yes, my lord.
Then only respondent
Await on respondent number 6, my lord.
service report on respondent number 6 is awaited. No, not awaited. Notice could not be served on respondent number 6 because the respondent number 6 could not be traced out. Addressee, oh, no. Oh, traced out, no, because the address was not complete.
Yes, my lord.
Because the address was found to be incomplete. Notice to be served in the proper address. List the matter after 2.
After.
Notice to be issued in the proper address, list the matter after preservation.
Obligement.
Item number 31. Delay condonation?
Delay on 240 days
condone-
delay. I have filed written objection, madam.
Objection, yes.
Yes,
There will be objections.
yes,
It's not 1000 days,
yes, 240 days.
40 days.
Yes.
Can be condoned. Where are your reasons?
Lordship.
You want a cost?
Yes, Lordship may impose cost, madam.
Lordship, regular first appeal I have filed.
Where are your reasons?
Lordship.
Main grounds are para number 3 and 4.
Okay, third learned counsel, Miss R. Chaudhary for the applicant. Kasam Ali, who has filed his application under section, Kasam Ali, no?
Kasam Ali.
For under section.
Order.
Under order 41 rule 3A of the CPC with a prayer for continuation of delay of 240 days in filing the connected RFA. Heard Mr. S. Dr. Learned counsel for the respondent
Respondent 1 to 4.
for the opposite parties, respondent number 1 to 4. What about this government advocate?
5-6 Lordship, Government of Assam. And
They are
7-8.
not present today.
They are not
Morning,
present. Earlier
he
days to
was
present.
Morning they were there.
Yes,
It's okay. It is submitted on behalf of the applicant that the title suit TS title appeal, no? This first appeal or second appeal?
First appeal, RFA.
Title suit was decreed, how much, what title suit?
No, Lordship, title suit was not decreed. My title suit was rejected, but by res judicata. So
Okay.
regular first appeal I have preferred
Okay, okay.
against that order.
Title suit number 337.
Title suit number 26 of 2022 in the regular
Title
first appeal.
6 of 2000 or 26 of title PS number 26 of 2022 was rejected.
Why the order dated? 22/3/2000.
Order dated
22/3/2024.
22/3/2024 on the ground of res judicata.
Yes, Lordship.
Full stop.
As because lordship, there is another suit pending between, which was filed by the sister of this present appellant lordship. The regular second appeal is pending before this court lordship. So I filed my impleadment application to implead myself in the regular second
No,
appeal.
but the reasons of delay?
Reasons of delay, lordship, though we have filed that application, the court directed us, lordship dismissed my petition on the ground that you are not impleaded by the appellant at her own cost, lordship. So you need not to implead yourself in the regular second appeal. The outcome of the second appeal will be without affecting me. So my application was dismissed, lordship. Then they dispossessed us from the suit length. So later on, I have filed another title suit. That title suit, lordship, the learned civil judge senior division held that already there is a case pending between the parties before the Honorable High Court. So this is a res judicata, lordship. In fact, in regular second appeal, I was not made party. But they have challenged my judgment, which was filed by me in title appeal.
As the suit was barred by res judicata लिखिला ना? Dismiss as the suit was barred. As the suit was barred by res judicata लिखी दिया. It is submitted that the applicant was under the impression that his case was under consideration before this court, this High Court.
Lordship.
As his, and his suit may be revived by this High Court, full stop. He did not inform about passing of the order immediately to his engaged counsel appearing in this court, full stop. Later on, after withdrawal of the interlocutory application, when the engaged counsel of this court called him, engaged counsel appearing in this court, called him on 26/5/2024 and informed that his case was withdrawn. Because even if any decree passed by this court in RSA number 355/2017, that will not affect him in
Yes.
affect him in
In
future.
future.
AFFECT, affect him in future. The applicant then took certified copies and returned home on 27/2024. And then he approached his engaged counsel in Guwahati or in his district. Where is his district?
Dhubri, lordship.
In his district at Dhubri on 9/6/2024.
There's a mistake in the date.
What is
Yes. He went back to his home on 2/7/24.
it?
Then after completing his personal work, he approached 9/6. He goes back in the 15.
It ought to be 9/7, lordship.
On 9/7/2024 and consulted with his engaged counsel. So after going through the documents, his engaged counsel asked him to meet him on 23. Then again, there is a
Lordship, that is also
23/7/2024. Consequentially, this resulted in the delay of 240 days, full stop. The learned counsel for a respondent has raised serious objections stating that the delay has not been properly explained. The laches and negligence is apparent as the delay is a prolonged delay of 240 days. I've considered the submissions at the bar. It is submitted that the applicant will be highly prejudiced if delay is not condoned. Considering all aspects, it appears that Melafadi is not discernible. Full stop. Grounds have been shown. Consider full stop. Thereby, the delay of 240 days is condoned. Registry to register the connected appeal.
Some cost to
Some-
the parties.
Lordship, there are several judgments, Lordship, liberal approach should be taken by the courts, Lordship. I am not citing, though I have brought some judgments.
Application is disposed of with a cost of rupees 1%. 1,000.
To be deposited.
To be,
The registry.
if I leave it as that, it will go directly to the other party. If I leave it as that, it will go directly to the other party, but to be deposited here and there.
Lordship. Then I can pay cash amount to him.
To the registry, madam.
Huh?
To the registry.
You want to send it to the registry?
They can collect
The withdrawal of that 1,000 will
They can
become a
collect it from the
harassment for
register.
him.
That's why I'm saying I'll leave,
Yes,
then
madam.
you decide how,
Madam.
in whatever manner. That is why I'm saying,
Madam,
if it like
Habla esta.
the winning party will get the cost.
Highly obliged.
Lordship, I have filed application by the respondent of the claimant side for withdrawal of the money which has been deposited by the insurance company long back, Lordship. And we have
Okay.
made.
You have any objection?
Yes, your lordship, we have filed your objection, your lordship, in the month of
Why?
June, but it has not been tagged here, your lordship.
Withdrawal of the deposited money.
Yes,
Yes,
Lordship.
and they have already admitted that money has been deposited also,
Yes,
Lordship.
lordship, we have
Yeah.
deposited the money, that's why they have filed for the withdrawal.
Hmm.
But we have also filed our objection, but the same has not been tagged along in the court.
Okay,
records.
okay. Let the objection come
Yes, your lordship.
after vacation.
Much obliged.
Lordship only fix the date, Lordship. Otherwise it is difficult.
After vacation, date
After
for video.
vacation was
Learned counsel, Mr.
DK Kolita.
D.K. Kulte is present for the applicant and learned counsel, Miss
A. Biani.
A. Biani is present for the insurer. List the matter after puja application. Registry to place the objection.
Objection petition
Objection by the insurer on the record.
in IA 1700.
Record of IA 1700 2025. Okay.
Much obliged.
Much obliged, your lordship.
Item 36.
Meet your lordship. Your lordship, as per office, there is service is not completed, your lordship. Service is not completed, your lordship. I mean,
Awaited.
justice service, your lordship.
You want to take justice service?
Yes.
Learned counsel, Mr.
S. Diffusa.
S.
S. Diffusa. Diffusa.
Diffusa is present for the applicant. Service report on the respondent is awaited. Justice service is permitted. List the matter after pujarification.
Yes, sir. Obliged, your lordship.
Item 37.
May I please, Your Honor? In this case, on last occasion also, there is a IA lordship, IA civil number 2749. This is an application seeking injunction, lordship. On last occasion, they were absent. And on last occasion, Your Honor told that on next date, the interim may be considered, Your Honor. Lordship, matter is that they are intentionally avoiding every date, Your Honor, so that an injunction order may not be passed against them. They are constructing a residential house over the suit lane, Your Honor.
Have you issued notice?
Already they have appeared.
Okay, they have appeared.
They have appeared.
In
Matter
I-
already
in I,
admitted.
in I.
In RSA number
No,
one,
not in RSA, you will have to issue notice in I also.
they have received copy. We have served them copy already. As because during pendency of the appeal, without serving copy, I may not. IA is not registered here. They have appeared. RSA is already been admitted. Now after admitting the RSA, Your Honor,
Issue notice.
it's already.
RSA, I understand that original, I am not asking you to issue notice there. It is admitted.
Admitted. And in the RSA, they have appeared. They have appeared. They have filed Wakalatnama and their name has been already shown in the cause list, Your Honor. Service complete already, Your Honor. They have appeared by filing Wakalatnama. So
The
urgency,
RSA is fixed today? No.
RSA is not fixed today, Your Honor. RSA is already,
Fix it along with the RSA, let them come.
RSA is all with the record, Lordship.
Okay, I won't issue notice as it is an RSA.
Lordship,
but
my
if
humble
it's
submission,
the RSA.
my humble submission,
No,
Lordship.
no, if it is taken up in this manner, then they won't turn up.
Lordship, actually what happened, Lordship? They have called us today. They told that they will seek adjournment for 3 weeks for filing written objection. They have over telephone connected us, but now at this moment, they are absent, Lordship. They may file objection after 3 weeks or after vacation, Lordship. My interim may be considered as because they are very.
I'm sorry, actually my senior has some difficulty, lordship. It's a medical emergency, lordship.
they want to file objection, we have no objection here, they can file objection, but our interim may be considered as because they are very speedily constructing
No,
house.
see, how will she answer for her senior? Her senior is not well.
Medical hurry
Okay, then, Lordship, you want to file written objection.
objection.
They may file written objection, Lordship. My humble chamber, as per the previous
No.
order, Lordship,
See,
the
she has
interim may be
come-
considered. As because the injunction application become infrastructure.
Her senior is not well.
No.
When you were
After vacation,
immediately
Lordship.
after puja vacation.
Then, Lordship, our injunction application will become infractuous, Lordship. As because if they tell that they will not, they will stop the construction, then it is okay.
Lordship, I have no
Till next
instruction.
day, they should stop construction.
Lordship, after vacation, Lordship. We want to
Then
file
after vacation,
objection.
they will construct the residence that.
Why are you bothered about the construction? If you have a good case, then it will be demolished. Let
No,
them
Lordship,
construct what they
that
feel like.
plot is adjacent to us. And we have some plan with that plot of land. This is a market area here.
Where?
Near Ronghar, Lordship, at Sibsagar district. This is a market area. We are planning to construct here a marketing complex, but now they are constructing a residential house. That's why the problem.
Lordship-
The nature and character of the suit land will be changed. I think they will not be prejudiced if till next date the construction is stopped. They will not be prejudiced, Lordship. At least till next date, the
You are
construction.
the applicant and you construct a market. And they are the one who has got the degree and they can construct the
But
house.
as per the facts of the
Lordship,
case,
can
they are
I adjourn
enclosure.
the day, Lordship?
They are enclosure, Lordship. My humble submission, if till next date, at least till next date,
Concurrent
Lordship,
judgments against you or reversal?
reversal judgment.
Lordship, I have no say about the matter, Lordship. Kindly adjourn the day, Lordship.
What is your senior suffering from?
Lordship, my senior family members in ICU, Lordship.
Okay.
Also, they want to file examination. I don't have any reply. They can take sufficient time. But my humble submission also, if the construction is not stopped, then the injunction application will become infractuous, Lordship. At least till next date, Lordship. Then they file objection. Their senior will come. Lordship will hear the both side. But till next date, Lordship, at least. As because my injunction application will become infractuous, Lordship.
Where is the judgment in title appeal? Judgment in title appeal?
RSL, Lordship. Lordship, what happened in this case, our suit was partly decreed, Lordship. One schedule was not decreed in favor of us, but other schedule has been decreed in favor of us, Lordship. And their question is the main substantial question is related to a oral gift, Lordship, as per Mohammedan law. And we have a very good case, Lordship. So we are in a hope that we will definitely get decree in this case, Lordship. That's why we are very in trouble that they are going to construct about a suit land. I think they will not be prejudiced if the construction is stopped till next date, Lordship. At least till next date.
I'll have to go through the judgment at least.
Yes, definitely, Lordship.
Interim ex parte injunction. Where is the judgment of title appeal?
Judgment of title appeal is at, Lordship.
She won't be able to submit anything in for her senior, so it will be an ex parte order.
Lordship, kindly adjourn the day, Lordship. After puja vacation,
No, if I give an order, I'll give only an order of status quo. Not a complete injunction order, only a status quo order.
Only status quo, Lordship. Only status quo. Only status quo.
Show me the title appeal.
At page number 56, Lordship, of the RSA. Sir, after hearing the other side, Lordship may may vacate the interim order, Lordship. But at this moment, Lordship, till next date, my humble submission, Lordship.
Yes, yes. Page number 56.
Page number 56, starting from page number 56, Lordship.
Yes. You are the respondents in the appeal?
I am for the appeal. Lordship.
No, no, in the title appeal?
Title appeal, I am appealing, Lordship. Two substantial questions of law already framed, Lordship.
It's okay, I'll just go, I'm going through the appeal order.
Sorry, Lordship.
Which is your injunction application? Only schedule B land then.
Only for schedule B.
Okay. Only schedule B land, you'll maintain status quo till the next date. First day on puja vacation, then you file your objection.
Objection.
Learned Counsel, Mr.
UB Sharma, Lordship.
UB Sharma
Yes, Lordship.
is present on behalf of the applicants, and Learned Counsel, Miss
R Dev on behalf of AR Shom, Lordship.
R. Dev is present on behalf of Learned Counsel, Mr.
AR Shom.
A.R. Shom, Learned Counsel for the respondents. Full stop. The Learned Counsel for the applicants has submitted that the respondents have started to encroach a part of the Schedule B of the suit land, which is described in the Schedule B of the plaint.
Yes, Lordship.
And in a surreptitious manner, they are preparing to construct an RCC structure, and this will change the structure of the Schedule B land to the detriment of the applicants. Post of the Learned Counsel, Miss
R Dev, Lordship.
R. Dev has submitted that her senior is not well. That her senior is not well now, that her seniors in this post as a relative is in ICU, full stop. The Learned Counsel has prayed for the respondent has prayed for adjournment to submit their written objection against this injunction petition, full stop. It appears that that an order of status quo may be passed at least till the next date of listing, full stop. Both the parties are directed to maintain a status quo as on today over the Schedule B of the land described in the schedule of the plaint of title suit number.
Your Honor, title suit number 101/2006.
TS number 101/2006 and TA number
TA number 16/2019.
16/2019 till next date at the till 13 October, full stop. The objection and prayer to vacate this order of stay or the order of status quo will be considered on 13th October. I'll correct the order.
Highly obliged.
I think after I'll just check it and it will not be to your disadvantage. Correct some sentences.
Obliged.
Item 41 supplementary cost list.
Oh, no, dispose no one. It will very issue notice na lage for.
Lordship, this IA is relating to condonation of delay
Okay,
in filing our cross objection for enhancement. Insurance company has filed an
no
appeal.
objection.
No objection.
Learned Counsel Mr. S.K. Pudra is present for which one I?
2696.
2696.
Yes.
3293, Lordship.
3293.
3293/23.
3293 लिखिएगा.
Wala faja. Delay.
Learned
Both
Counsel
applicants.
Mr. S.K. Pudra is present on behalf of the applicant.
Petitioner, Lordship, here. Applicant. Cross
Petitioner who has filed a cross objection number.
26.
It has been filing number only, not yet registered. Lordship.
Not condoned, yes. Who has filed a cross objection against the MSC number.
In MSC appeal number
602 2022.
602.
Learned Counsel Miss B.
L.
Sharma,
Sharma.
huh?
L. Sharma.
L. Sharma is present for the insurer.
Yes,
And
insurance
Learned
file.
Counsel, huh?
Insurance company.
I'm respondent number 4, my lord.
Learned Counsel
DK Barua.
VK.
DK Barua.
VK Burrow is present for the respondent number 4. There was a delay in preferring the cross objection against the
20
MSC
days.
number. Huh?
20 days delay.
In preferring the MSC number 602 of 2022 or 23.
In preparing the cross objection, Lordship.
Or in preferring the cross objection, yes, against the MSC number 602 of 2022. The Learned Counsel for the insurance and respondent number 4 has no objection. Delay has also been properly explained. It appears that there is no mala fide on the part of the applicant. Delay of 20 days is hereby condoned. Registry to register the connected cross objection. In terms of the above
Maybe listed
observation,
accordingly.
application stands disposed of.
And maybe listed accordingly. Registered and
Yes,
listed.
Register and list the.
Because we have a
cross
another appeal, connected two appeals are there in this case. also.
Obviously. Oh, come to the appeal, sir.
No, that will come after
Okay,
this,
okay.
after listing, it will, we will tag it.
Alright.
also.
Problem.
After registration of this, we will tag it. also. Okay, to give us. Okay.
After hearing, will we be able to complete hearing today?
Yes, it will take small time, 5 minutes.
Okay.
But it was an already, it is a part matter, Lordship.
Pattern method.
Yes. So, my lord, it is best enhancement, my lord.
Huh?
Enhancement.
Okay.
The award was amount of rupees 3,24,600.
Yes.
88, my lord,
Mm.
in favor of the appellant. Now, the appellant wants enhancement of the judgment and award, my lord.
Mm.
This is the case. The crux of the case is, my lord, the appellant is a pillion rider. And now the judgment is given in favor of him, 3,24,688. Now the appellant wants enhancement. That's because 4 lakh something he has incurred cost for medical expenses. The learned tribunal did not consider the same. So that is why this appeal before your lordship, this honorable court.
Okay.
Now in the impugned judgment, what a different, my lord. The insurance company did not adduce the policy of the insurance, which was that the LCR page 139 policy report. If your lordship kindly have a look, there are 2 types of policy. One is Act policy and one is comprehensive policy. The present insurance cover is Act policy as far as alleged by the insurance company, but it was not produced before the court below. And on the basis of the submission of the respondent insurance company, learned tribunal passed the judgment and award, which is in my favor, even though the same award is very minimum.
Okay.
That is why the appeal was filed. The appellant is a pillion rider, and now the only liability is, my lord, pay and recover. Nothing else survived. Pay and recover.
Okay.
The judgment is, my lord, in page number 21 of the judgment of the appeal memo, page number 21.
Page number 21, yes, appeal memo.
Page number 21. Issues framed, my lord, 2 issues were framed, and while discussing the issue, para number 4, page number 21, it has come during the trial that the offending vehicle was insured with opposite party number 1, and the policy number is so and so, and the validity of the period is so and so, so and so, and opposite party number 1 and 2 denied the abatement made in the claim petition, but failed to show that at the time of the incident, the driver did not have valid license or has prevented from driving vehicle. The driver has the valid license. It was proved. The claimant PW1 exhibited documents like 54 MBI report and medical documents, etc. Para 5, PW1 Krishna Chauhan claimed that he is an eyewitness of the incident from a close range. The total medical expenditure is estimated 2,65,688 from 7/11/2013 to 21/11/2013. The claimant was remained as an indoor patient in Hayat Hospital, Guwahati. In Hayat Hospital, his injury was diagnosed: head injury, brain contusion, BL right temporoparietal, EDH, SDH with calcaneal fracture. The claimant claims to be a businessman and his monthly income is shown as rupees 7,500. It has come in his evidence that how long the claimant was away from business. However, it is held for the 3 months he was away from his business profession. The claimant also did not make any effort to show his quantum of monthly income. Therefore, his monthly income is considered as rupees 3,000. So his loss of income will be rupees 9,000 per month. For non-pecuniary damage such as pain and suffering, nutrition, food cost, convenience, etc., rupees 50,000 is awarded. Thus, the claimant is entitled 2,65,688 plus 9,000, in total 3,24,688. The insurance policy was liability policy. That is the crux of this case, my lord. The insurance policy was liability policy. Since it was liability policy and the insurer pillion rider is the liable. In the general insurance so-and-so company limited so-and-so, it was held that Honorable Apex Court that insurance being statutory policy does not cover the risks of death of bodily injury to the gratuitous passenger pillion rider. The insurer is liable for compensation on the death of injury of a pillion rider only in case of comprehensive policy. That is the bone of contention in this case. The opposite party number 3, Kanaj Kumar Brahma, is directed to pay the aforesaid sum to the claimant with an interest of rupees 6% from per annum from the date of filing of the case till payment is made within a period of 3 months. In default, another interest per annum will be imposed on the same. Now, my lord, my prayer before your lordship, since the award amount was given to the insurer, the owner of the vehicle. Now, my claim is for enhancement of the compensation. Apart from this, my also claim is to pay the liability upon the insurance company and recover from the insurer. That is my prayer before your lordship. In support of this, I cited the Supreme Court judgment for pain recovery. Your lordship is very well aware for pain recovery.
Yes, yes.
Page 13, para 13 of the judgment. Last part, para 13.
Okay. Yes.
The residual question is what would be the appropriate direction? Considering the benefit object of the act, it would be proper for the insurer to satisfy the award, though in law it has no liability. In some cases, the insurer has been given the option and liberty to recover the amount from the insured. For the purpose of recovering the amount paid from the owner, the insurer shall not be required to file a suit. It may initiate a proceeding before the executing court concerned as if the dispute between the insurer and the owner was the subject matter of determination before the tribunal and the issue decided against the owner and in favor of the insurer. Before furnish security for the entire amount, which the insurer will pay to the claimants, arises the executing court shall take assistance of the regional transport authority concerned. The executing court shall pass appropriate orders in accordance with law as to the manner in which the owner of the vehicle shall make payment to the insured. In case there is any default, it shall be open to the executing court to direct realization of by disposal of the securities to be furnished or from any other property or properties of the owner of the vehicle, that is the insured. In the instant case, considering the quantum involved, we leave it to the discretion of the insurer to decide whether it would take steps for recovery of the amount from the insured. So that is the judgment clearly. The guideline has been given how to recover, how to utilize. So this judgment will be sufficient to.
Yes.
Lordship, in this case, we specifically pleaded that policy was an act policy and there was no coverage for the pillion rider. And the policy was also produced before the trial court. And the trial court, after considering evidence on record, has exonerated us from liability and liability was fastened upon the insured of the vehicle. Lordship, only the Supreme Court has the power to pass pay and recovery order. Except Supreme Court, under Article 142, no court has power to pass pay and recovery order. Lordship, our High Court as well as the Apex Court has clearly held that in an act policy, there was no purpose for the pillion rider and the insurance company is not liable. One kind of decision. Earlier, I have furnished the Chiloxic decision and other decision. These are squarely covered with this case. The claimant was injured in an accident. He was the pillion rider of the vehicle. It was an act policy, and the liability was fastened upon the trial court. Liability fastened upon the insurer, and High Court has reversed the order, set aside the order, and it was fastened upon the owner of the vehicle. It was squarely covered with this case. I have furnished the Supreme
This,
Court decision as well as High Court.
Only the Supreme Court has power,
Yes,
pass
yes,
an order
Supreme
for
Court has
pay
power.
and recovery.
My lord, Supreme Court has power under 142. It is,
142, except
universal.
Yes.
It is under 142, but
Yes.
in this case, in all the cases, Supreme Court is not exercising power under 142. The law is there. A motor vehicle act law is there. Appeal is there. In exceptional cases, when for the ends of justice, it is required to pass an appropriate order. By that point of time, Supreme Court exercise the power under 142. Otherwise, it not utilized. In other judgments are there, Supreme Court never utilized this. Only in one case, I have this judgment also. In one case, Supreme Court exercised the power on 142. Apart from this, my lord,
According to him, only Supreme Court has the power.
you see, Supreme Court has the power. I respectfully admit before your lord, Supreme Court has power. The law is
Then
clear.
will I pass an order for pay and recovery then?
While this court, in the judgment I have given, the Supreme Court has not utilized 142. In other case, my lord, the Supreme Court has utilized 142 also.
This is
My lord, I
140.
have judgment. This is in my case also. Another case, Supreme Court is clearly mentioned 142. Kindly have a look. In this judgment, Supreme Court is clearly mentioned 142. Last part. Last part, paragraph.
Yes.
Last paragraph. Even in my recent case, in one of my case, pay and recovery is given by this honorable court.
Let me see.
The last paragraph, 142 exercised by the Supreme Court, honorable Supreme Court.
Okay, we'll reserve and pass an order.
Obliged.
Third learned counsel, Mr.
I.A. Talukdar.
I.A. Talukdar for the applicant and learned,
Okay,
for the appellant and learned counsel, Mr.
KK Bhatta.
K.K. Bhatta for the insurer, reserve for judgment and order.
Obliged.
Yes, my lord. My lord, we filed two IA. These two IAs are not listed here.
Okay.
So matter may be posted after.
You have filed two IAs.
Two IAs.
So this case was listed on 11th.
Ah.
It was not listed there, not listed thereafter. This matter has got some urgency. They are harassing the respondents like anything. And my lord, the suit has abated in 2023. Now they filed an application, my lord. Initially, a defective application was served on me, my lord. Then it was again rectified. Now I don't know, my lord, this has been almost, we have filed a reply.
It is, IA is only for the setting aside the abatement in the delay application.
I understand, my lord. That
Maybe
was
posted after the application. my lord.
my lord, a defective application was filed, served on me, my lord. Then it was rectified by serving another application. And now, my lord, this case was fixed on 11th. In fact, the last occasion was listed. We have filed an objection also, my lord. I don't know why it has not been listed, my lord, and there's no, these persons have been harassed like anything, my lord. Let it be, lord, before the vacation any date, my lord, otherwise will inconvenience.
cannot
I understand. No, it's not hearing, my lord. It's only for orders, my lord. It actually ought not to have come for hearing.
Okay.
It's for orders only, my lord.
Orders are coming, DD will DD.
Along with the IAs, my lord.
List this matter in the orders column along with the newly filed
Client is harassing.
I is already filed, my lord. It's not vacation, my
along
lord.
with the newly filed interlocutory applications, list the matter. 25th September.
1983 and 1985 of 2025.
Numbered as 198.
3 of 2025 and 1985 of 2025.
Okay.
Well, there is another IA which was IA file, 3819 of 2024. That may also